Hello, good morning. Happy sentencing day. This is gonna be fun. Yeah, sorry, I decided to start a little bit later just because. But I mean, without further ado, let's just jump in and see exactly what's going on. Getting right into it. Let's maybe do this one. Party time, people. Party time.
Okay.
I've got a couple of streams lined up just in case.
No. Advocate Olis, I just want to make sure, is there a microphone in front of you? If you can just... No. Oh, if you can just... Okay. Thank you. I just want to establish one aspect. Although we filed the heads, are you not of the view that at least our record should reflect what is contained? Because if we get to transcription, this is obviously not going to form part of the formal record. So if it takes time, it's fine, but it won't be on the record if it's not.
It's my intention to deal with the heads of myself and my lawyer for the record. It makes no sense for me to stand there, read my heads, and he reads his heads. So I'm going to anticipate his heads and then give him a chance to then deal with my submissions.
Oh, okay. I now follow you.
In fact, Your Worship, my intention is to go as to what happened on the last occasion.
Oh, that's awesome.
What's then
Switch
transpired,
the matrix.
followed by the heads, a few submissions, and conclusions. I want to be long with Your Worship. I do believe that we can...
Wow, they always have such great audio in the court, eh? Lovely stuff.
Thank you.
Worship will by now have a copy of the transcript of the previous occasion. So just to put everything into context, Ms. Thompson testified on the 23rd of January 2026. But after this matter was postponed to today, and possibly tomorrow. And what happened in that regard, Your Worship, is quite clear, is that I asked the court to inquire from the state, this is page 172, whether they had in fact closed their case, and they said the state has not formally closed their case, and we're waiting to hear. Thereafter, they formally closed their case, Your Worship, and said that they're not calling any evidence in aggravation of sentence. That's from page 172 onward. What then happened, Your Worship, was there was an agreement that we file our heads of
Microphone, audio.
March.
Oh my God.
Your Worship, 2 weeks.
Tell me.
We'll go through the heads of arguments and be ready for today. And we now know that we filed on the 31st of March, Worship, that absent this case that I intended to include in the heads of argument.
Oh, there we go. Finally, somebody figured it out. Oh, no, it's just one side. God.
Thereafter, Your Worship, the state filed supplementary heads last week, Thursday.
Audio. This isn't me, this is the stream. I'm sorry, guys. This is wonderful. Great. Well, I mean, it's the EFF streaming this. Tech support, the EFF side is not the best. Not the best. There we go. Well done.
So that would set the factual background to where we are at this stage, Your Worship. Now, turning to the heads, Your Worship, if I may take Your Worship through our heads, just by way of introduction, and I don't intend to stand before Your Worship and read every day. But what we did, Your Worship, and my learned from the doctor, the similar approach in his introduction is we described by way of introduction the offences of which the accused has been found guilty. There are 5 words that may be summarized as being unlawful possession of a firearm, unlawful possession of ammunition, the unlawful discharge of a firearm in a caught-up area, the unlawful failure to take reasonable precautions to avoid danger to personal property, and finally reckless endangerment to personal property. So those were the 5 charges, Worship, on which the accused was found guilty. And then what we highlighted and emphasized throughout the heads, Worship, is that all 5 charges relate to a single incident, being the 5th Economic Freedom Party celebration that occurred on 28th July 2018, at necessity quasi stating in Tanzania within the jurisdiction of this honourable court. And what we say, Your Worship, and it's highlighted further throughout the argument, is that all 5 charges were committed in a very short time span of less than 1 minute. And then we then also, and we had agreed on this previously, Your Worship, that there was no indication that any minimum sentence legislation applied in this case because the accused had not been warned accordingly. And I do believe that there is common cause on that, so there's no need to go into the case of dealing with that particular aspect. And then we went through the report of Ms. Jessie Thompson, Your Worship, who was called to give evidence in mitigation of sentence. And she highlighted his personal circumstances, and more particularly that he was a 45-year-old first offender, having never been convicted of any offence. And we say equally significant to respect the fact that despite the lack of 8 years since the commission of these offences, the accused has not been convicted of any other offences. So he's 45 at the moment, he was 37 at the time of the commission of the offences, and he led a blameless life. In the interim, there have been no intervening incidents or anything that would aggravate the circumstances of this honourable court. We then summarised Ms. Thompson's report, Your Worship, and who she had interviewed and what information she utilised, and that she sought to follow the Zim triad and all the relevant considerations. And she had regard to his personal circumstances. And we say even that in relation to this in paragraph 13 of the Your Worship, the principle of remorse is found that the accused continues to assert his innocence. Nevertheless, she was of the view that the accused regrets the incident and the consequent result that people may perceive it as encouragement to handle firearms recklessly, which was not his intent. In that regard, Your Worship will know, and we received, as I recorded, Your Worship, the transcript of Your Worship, this also in questions of clarification, and made it clear, Your Worship, on the record, and I can give the reference to Your Worship, that people are entitled to plead not guilty, that is their right. Your Worship, to put that to Ms. Thompson as a clarifying question, and she had agreed in that regard, Your Worship.
Sorry about that. Hold on a second. Let's see if this is... There we go. Sorry about that, ladies and gentlemen. Glitch in the matrix.
Argument say it ought to be an aggravating factor. I think they're missing the point. Let me make it clear, also. When we
Just very soft
that
for
one
some
cannot
reason.
find any cases
They can't sort out microphones.
But the point is, also, if one has regard, and I'll even ask the court to take judicial cognizance of this. When you watch
Thanks, Matthew.
funerals of prominent leaders and other...
I just want to get to the judge.
Very often there's firearm shooting because people aren't charged. And there's no case that we were able as a team, a large team, to trace that we deal with such instances. And that's the point that we're trying to make, that it's very unlikely, and it hasn't happened in the past, that people were charged with those offenses, even though we see them on TV on a regular basis. Then Ms. Thompson recommended, as do we, that all 5 charges arose from a single incident and the accused had not loaded the firearm. The charges should thus be considered collectively for sentencing purposes, now was taken together. She then proposed a monetary fine, that the accused be restricted from obtaining a firearm license for a particular period, and a monetary donation. In the heads, we worship in paragraph 22, we deal with the cross-examination, and that it was put to her, and it's now on the strength of the listed decision from the judgment, that to impose a monetary fine would be aware of, would be conveyed...
Oh, they're going for a monetary fine. Of course they are.
But her response to that was that jail is not necessarily the correct way to go. So we say, Your Worship, is that even though the states take exception to the possible imposition of a monetary fine, we say that this is still constitutionally recognized as a possible offense and ought to be taken into account. Then she was re-examined, Your Worship, and then the court asked clarifying questions, and that's where your Worship asked for clarification, as I've dealt with, as to the plea of not guilty, which one is entitled to do the
Same here. Same here.
proof in the lack of remorse, and that the Worship also clarified the substantial contribution made by the accused to the community with the soup kitchens, and that there are several other soup kitchens that she had explained that it used his money to do it, and he'd given money on his previous birthday to the establishment of funds and charities, which is in the report. Then we say in paragraph 24 that Ms. Thompson was of the view that there was no risk of the accused recommitting such an offence again, based upon the passage of time since the commission of these offences, and in not having done so in the interim, which is something that I've already alluded to. Then, and I think it's important that I clarify this because there seems to be some confusion in the heads of the states in this regard. We refer to general principles of the Constitutional Court concerning sentencing. In particular, we dealt with statements of Makmanyani when the death sentence was abolished, and we highlighted paragraph 222, which is something that the state and the supplementary heads also highlighted at the very same point. And the point that I wish to highlight there was, and I'm not going to quote it extensively, is that the state not only preaches respect for the law and the killing must stop, but it demonstrates in the best way possible, by example, society's own regard for human life and dignity by refusing to destroy that of the criminal. So all our sentences are blended with a measure of mercy, going back to the Rabi decisions, etc., etc. We then also, on this principle, refer to the Constitutional Court decision of EFF versus the Speaker, National Assembly. And we said, and this is the quote from paragraph 235, and ironically, they also refer to this in their heads, Your Worship, in the middle of 235. It is, after all, the embodiment of the legendary Lady Justice, a dispenser of justice who is blind and deaf to images of any reports on the good reputation or notoriety or personality before her, and never misses any legitimate and relevant legal or factual points for or against any litigant. And then this court is required to always display the critical boldness to go against overwhelmingly popular and forceful opinion. And then we also deal with the Constitutional Court decision finding the worship of Sengwedi, paragraph 27, 2022 decision. It says our court must defend and uphold the Constitution, the rights entrenched in it. One of the most important rights from a historical perspective is unquestionably the deprivation of an individual's liberty. The court said in February that conceptually, individual freedom is a core right, the panoply of human rights. The apartheid regime repressive and capriciously deprived people of their freedom and the illegitimate legislation that paid no respect to the rights to freedom and security of the person. We are therefore constrained to jealously guard the liberty of a person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. So those were the cases that we cited on general principles relating to sentencing. We then turned our attention, in our heads, to sentencing concerning firearms. And we had regard to the article that one of the friends provided to us of Troy, relating to a note on sentencing practice in defense of the unlawful possession of semi-automatic firearms, and that what they had utilized the support that there should be a period of incarceration. And we quote from the report, Your Worship, we say, just quoting the second paragraph here, from the investigation, it's evident that courts are more likely to impose a minimum sentence in cases where the accused is also convicted of other serious offences, such as murder and robbery. In such cases, little attention is given to the firearm-related offences, as the courts are more concerned with the cumulative effect of the sentences imposed on different counts. They also then refer to the decision of Mork. It's on the next page, which we say, from the Supreme Court of Appeals judgment in Mork, it appears that the circumstances under which the unlawful possession occurred and the purpose for which the semi-automatic firearm was possessed will play a pivotal role in determining whether substantial compelling circumstances justifying the imposition of a lesser sentence exists. There's a reference to Dalport and the gradation, which is also referred to Mayorhead. And there's a quote that the grading of the offence will typically be informed by the risk of harmfulness and the culpability of the offender. But then to make the bold submission that I've already made to Your Worship, that the minimum sentence regime does not apply in this instance, and that's in paragraph 29.
So it's obviously just appealing to get the lowest sentence possible, like a fine, I'm assuming.
Reference, and we quote from that decision. We say what is notable from these cases is that imprisonment is not always the norm. And then we say as follows, that turning to paragraph 33 now, that
Appealing to the judge.
Case law, we said that the circumstances of the possession are a central factor. If the context of the possession is part of an overall commission of violent crimes, the court will generally incline towards a harsh sentence in keeping with the objects of the legislation. That's logical, Your Worship, speaks for itself. If the firearm is used to commit a murder or to commit a robbery, it's far more serious than the firearm that isn't used to commit another serious offence, which is what is the case here. Secondly, the purpose behind the possession is also another factor that emerges from some of the cases. They say, while not decisive, it is a factor that the court may legitimately take into account. Indeed, there is a vast difference between an accused who has been asked to temporarily keep a firearm while the owner goes shopping and the person who places a firearm in the boot is trying to hide it from the police. And thirdly, the duration of the possession is a relevant factor. An accused is being in possession of a firearm for an lengthy period, they cannot be treated the same. For sentencing purposes, as someone with fleeting possession of a couple of seconds, fourthly, harm is a critical consideration. Court should consider what the harm is. We accept that possession is in itself a harmful thing, but there are degrees of harm caused by possession, so the court would need to satisfy itself about the harm it seeks to punish. Possession in celebratory context for a few seconds should be considered differently. And that's our submission. And then from the cases, Your Worship will also note from whom and in what circumstances the accused received the firearm also by part. We then quote the Dalport decision of Brent's Ward, the Mitigation. We which determined on the circumstances in relatively innocuous possession. And we then turn in paragraph 35, which is the case on discharge of firearms. And we say that they also do not always affect incarceration, and that regardless as to the circumstances in the context of the discharge, we then refer
Yeah,
to
Matthew, that is one thing that might will most likely happen. If he gets a prison sentence, maybe I think highly chance of them going, let's burn shit. So, you know.
Pistorius decision, where there was a shooting in a restaurant in Norris by the name of Tasha's. Under the table, there were over 200 people in a very confined room of the restaurant. Fortunately, there were no injuries, but there was damage to the floor. There was a Glock 27 pistol, and we said that's the most comparable to you, because we believe the witness was given his firearm back after the incident, and that he was the lawful possessor who handed it over to the shooter, but they told him not to shoot. Explained that in paragraph 37, there were 220 people in the restaurants. It was full at the time. The accused admitted that he had taken the firearm because he was planning to buy a similar model. His version was rejected. But in that instance, Your Worship, the accused was sentenced by the secret J to 3 years imprisonment, wholly suspended. So, in respect of the conviction in count 3, which was the shooting and discharge of the firearm, I've taken into account that no one was hurt, that the offence is serious and respectful.
I am sorry too.
I do not believe that the degree of negligence in respect to
No, it's going to be fun, guys. This is fun. Come on. Justice. Come on, let there be justice.
We then turned, Your Worship, and we went forward in time to 2021, 29th of April, the decision of Nsami and another Mississippi State, where 2 policemen
That's not a bad idea.
shot at somebody on a public area on a boat. And they were charged with attempted murder.
Actually, Andreas, I've got to do work as well, so I can't just be. Yes, I'm trying to do work as well.
And they received an appeal for a sentence of 7 years of mandatory fine from the Scape J of 12,000 rand and 2 years imprisonment that was wholly suspended. This was also referred to by Ms. Thompson, and we then highlighted the factors that we say very highlighted in that case, that no wounds were inflicted when the defendants discharged their firearms, there were no wounds or damage. Their intoxication was regarded as an aggravating factor, as was the fact that they were members of the SAPS. They said there in paragraph 14, same incident gave rise to conviction on unlawfully charged with determined to not engage in one act and then proceeded to engage in further criminal conduct. And then his lordship said to effectively punish these as separate actions is in our view contrary to what is dictated by a common sense approach, in view of the fundamental requirement of fairness and misdirection. And there was a regard also, Your Worship, as in this case, the appellant perceived lack of remorse as an aggravating factor. And there's regard here to the decision quoted by the state in the heads of argument of Hewitt, who says that it's not an aggravating factor that can be taken into account. We then looked at we cited the paragraph 18, Your Worship, where the following appears. The question is whether direct imprisonment is the only sentence that would, 1, take account of the interests of the victim by acknowledging the harm done to him, 2, inflict punishment on the offenders.
I mean, I don't know if he's going to get. He might get a jail sentence, but like, I'm 50-50 on this. He could get off, or the other thing is he could get jail sentence and then claim, it should be a shake vibes, where it's like medical parole for the next. But what I do know is if he gets a sentence longer than 12 months, he loses his seat in Parliament. And that's what he's trying to avoid here. This is why I think his lawyer is now appealing to the judge for the lowest possible thing. Going off, there's no precedent for this or some shit. Really, Chantal, really.
It says punishment should fit the criminal as well as the crime defect to society be blended with the mercy according to the circumstances. Then we have set out paragraph 20.
That is cheeky.
The fourth line, the goal of rehabilitation is to address the underlying factors that led to criminal behavior.
But AJ might agree, he is a useful political idiot. Very much so.
On the contrary, evidence shows that prisons rarely rehabilitate individuals but tend to further criminalize individuals, leading to reoffending in a cycle of release and imprisonment. There's nothing to reduce overcrowding prisons.
You guys are just mean today, eh?
We go further down in
Pay the
that
boo.
communities protected when convicted persons are removed from society. However, protected...
Yeah, no, they don't want to. They're not going... That's the thing. The judge has to... I mean, I wonder if the judge has to weigh those two things up, right? They've got to go... there's a causation of the EFF completely losing it, but is that maybe what the government wants? I don't know. So, I'm hoping he gets a sentence over maybe, even if it's a year, he loses a sentence. That's what I'm hoping for. Unless they go 6 months, you know, or something, or a massive fine. We then referred here to the decision of later. The stream is slow today.
Which involved pointing of a firearm, assault with intent.
No one wants to watch the Mork show.
Arrangement to put the property pointing of a firearm, in which a fully suspended sentence was imposed. So we say, with respect, that possession doesn't necessarily carry in its own.
I mean, for someone who's like an educated lawyer, right, like years and years,
then there's the new decision.
the basics of learning how to use a microphone is just not. See this thing here? The microphone. Maybe a lapel mic, something. Learn to pole, learn poles, and learn how to dance. I know, with that terrible excuse, right? Listen, you shouldn't go to prison because, you know, they don't really help.
Was alerted to two youngsters, to a bunch of youngsters that seemed that gone to a media room to try to steal things, and he ran after them and he shot them with an illegal firearm. He killed the one and injured
Peter
the other,
Savenga.
14 years old. And that man,
These guys, if you go follow Peter Savenga, go follow the Upper Room, great channel, absolute OG.
So we say that's a case, Your Worship, in this honourable division, where there was not only harm to one 13-year-old victim, but the murder of the other 13-year-old victim, Worship, and that person was not sentenced to jail in this division. We highlight, Your Worship, and I know Your Worship hasn't seen this, paragraph 10, where Justice Brooks says the offences of murder and attempted murder rank amongst the most serious of the common law offences. Indeed, there can be nothing more serious than the unlawful deprivation of another's constitutional.
No, I know, they're not. They're definitely not. I mean, there's a microphone, obviously, there has to be a microphone in front of, or at least someone holding a boom mic up, or a directional mic.
What is required is a consideration of the offence that takes account of all the relevant facts that are peculiar to the incident that defines it. We also refer, Your Worship, with respect to paragraphs 22 and 26. I know Your Worship hasn't had an opportunity to see this, so let me read them, Your Worship. 22, the court holds the view that all the aspects referred to above constitute substantial and compelling circumstances that would justify the imposition of sentences less severe than the prescribed limit. Given the irretrievable loss of life, count one in particular calls for a substantial period of direct imprisonment. However, the identification of this principle and objective isolation at the end of the inquiry. Uniquely, the interests of society in the context of the rural community means the death of the deceased do not necessarily require ongoing retribution for what has occurred, nor do they require that the community be protected from his disturbing environment by his removal from their midst. He is not a person who has shown a predisposition towards criminality that requires him to be rehabilitated or reformed. He poses no danger to the community or to society at large. He has made the necessary overtures to make peace with those families whom he offended by his reckless action. Obviously, the pain felt by the family of the deceased account on his real upon grave. Perhaps this was only dissipated with the gradual passage of time. It's not something that can be eradicated by the ongoing incarceration of Mr. Malema.
Yeah, I completely agree with you, Chantal. He needs to. That's basically what we want. We want to get him out of Parliament. But I mean, again, if he loses his seat, but the EFF don't lose their seat, right? They still have that seat. It just gets filled by someone else. And who would that be?
Should be highly suspended for a period of 15 years on condition that he is not convicted of any offence involving violence committed during the period of suspension. Then we come to the conclusion, Your Worship, where we say, prior to that, we deal with general principles concerning sentence, Your Worship. Just the issue of S versus Ora and another proportionality is important. We've got the custom and circle, which was acknowledged by Sadi Wallet J. Finding inappropriate sentences is a challenge faced by criminal courts daily. A sentencing is not a perfect exercise. What complicates this even more is that there may be more than one appropriate sentence in a particular case. And then there's reference to a footnote that sentencing at the best of times is an imprecise and imperfect procedure. There will always be a substantial range of appropriate sentences. But what we say, Your Worship, in 45 is that we've illustrated that mere possession of discharges do not always mean that there must be incarceration. Each case must be evaluated on its facts. The facts of this case are indeed unique. So first,
You guys. Fine. Okay, fine. You've asked for the. Oh, rain down the thunder now. Rain down the thunder.
Good one. Yep, that's a good one.
There's no obligation that the court has to imprison somebody for these offences. And then in the conclusion, Your Worship, we say that this was we adopt a cumulative approach. There are 5 charges. All that
Rev, thank you, good sir. Much appreciated. Thank you for the super chat, good kind sir. Very awesome of you.
It can be dismissed out of hand without more. We say the lawful and appropriate sentence cannot include a custodial sentence. Only a non-custodial sentence would be compatible with the principles of sentencing in South Africa. A deviation from that approach would simply show the accused to be singled out from duty harsh punishment. And we say that this submission is fortified by the objective fact that there were no injuries sustained by anybody and no damage to any property. It is also underscored by the fact that this is a single continuous event of no more than 2 minutes and 4 no harm to everyone.
Look how awesome I am. Look how awesome I am.
For this incident. In fact, nobody testified that they were in fear of the accused by virtue of the offences committed by him. And we also highlight, Your Worship, that no evidence was there in the aggravation of sentence. Now, Your Worship, as previously alluded to, and this is quite difficult.
Much appreciated, Rev. Much appreciated.
That these factors ought to be placed on record, so that there's a record of everything that was just referred to.
Oh, I'm cool. Pleasure. Oh, Rev Valerie. Sorry, Valerie. Much appreciated, Valerie. Absolutely awesome.
Heads of argument. As I said, Your Worship, I like the charges or whatever reduction as degree. And there are the view, Your Worship,
I've got poll apps.
that the custodial sentence is inevitable. And they say, and this is
My face is sexier.
self-defeating and
How long is he going to do this for? Like, is this what we're watching today? Just this dude like rambling on.
In the very next sentence, they say he's the leader of the political party. So
Why did I do this? Why did I decide to do this? Look, I thought I'd at least have a couple of viewers, but it's okay. It's okay. You guys are awesome. You're the most awesome viewers. All the people, you're the most awesome. You're going to get all the attention. All the attention is going to be for you guys.
There's supplementaries, and this is borne out to us in paragraph 8, where they say there's a huge outcry from civil society.
Look what I have, though. I've got this. Check this out. Check this out.
You can't treat
skip overlay.
acknowledging that he's the leader of a political party, but don't take that into account
check
that
out
at the same
that.
time
Never like and
society is
subscribe. That's sexy.
for his imprisonment. They then refer to the listed decision, Your Worship, which I've already referred to, where we acknowledge that imprisonment is a form of punishment and that it's an institution of punishment, not cure.
Oh, you traitor. You traitor. See, I'm just asking you, just for context, CR, did Ronaldo come out and hang out with you the other day at the Route 44 market? Did he do that? Did he come? Did he come, CR? No, he didn't. Who came? I came. I came really hard. No, I was there. I was. Thanks,
Hello
CR.
there.
Yeah, you take that back. You take that back. You fucking unloyal to you. I called you Andreas. I got it right. What are you talking about? I got it right sometimes. And I'm dyslexic, so I get like special extra points. What are you talking about? Yeah, but now only. Traitorous Jezebel. Your red hair. Fucking thief. Never trust a ginger. Never trust a ginger.
He did not have it for a long period of time. Still, he got an 8 years direct imprisonment. In this case here, the accused also did not have the firearm for a long period of time, very brief. It does not change the fact that he's still sentenced to die.
The argument from his lawyer right now, where prisons don't reform anybody, must be you right in the, you know, that's a dick move from the lawyer. Shame Valerie.
I would not know why. The reason his wife was picked up in the spur of the moment.
How's it?
Also here, it is not
Heidi, how are you? Heidi from the Netherlands. How's the Netherlands doing? You know, we've been having rain. Oh my God, it's just babble.
The circumstances in total, what I hear what he said, that for me the circumstances gain are different.
Oh, is it? Is it? Huh? Is it?
To the state, what happened to it, which may also make it different. And that's the
What's excuse now, bitch? Huh? What's excuse now?
It seems
I came out and spent time with you. He doesn't do that. He makes everybody fucking.
Those were illegal firearms that have been adapted and were then seized by the state. Here, prior to even your worship's judgment, the firearm was returned to its lawful owner. Then my learned friend asks her further.
Oh yeah, you guys are going to summer now.
If you come across any case such as this, in a firearm-related case, possession of firearm, where an accused was not sentenced to direct imprisonment,
Wasn't me, okay?
and so on and so on. And she says, as I've not come across worship any case where a charge was laid and the firearm was used for celebrating.
I can never win.
She never
Right? I
ever
can never
said,
fucking win.
yes, I know of such a case, or I don't know. She says, I cannot find a case that there's a law force with this,
You know what?
because this is celebrating. Then he tries harming worship
I just
at
give
the
up.
foot of 97. He says to her, if you come across a case where an accused was convicted of being in possession of a firearm, whether it's for celebratory purposes, that is just social, for whatever reason, have you ever come across the case where an accused was not sentenced to direct imprisonment for being in possession of a firearm, whether it's just for a minute, for 10
It's
minutes,
not just
for 20
possession of a
minutes,
firearm you
once
cracked,
one
you
case.
shot it.
Worship I have not,
But also, how does this work though? Because his claim was it wasn't a firearm.
That most of them relate is in the context of other crimes that were committed with the firearm. So the possession forms part of
No,
those.
the upper room. That's the guy from. That's the guy that's the plumber and the doctor, and now he's a media stick. You know that guy? You know that guy? Yeah, the guy over there with the blue on. He's talking to his phone.
Say that she wants it differently, which is not the case.
You know who that guy is, right? That's the dude from the guy that's in the naughty movies. That's the plumber, the doctor, the pilot. That's him. Today he's a media guy.
The Delport decision, which I already referred to, the gradation, the Malchus decision, and now you also, with respect, they've gone to all the cases.
That's actually right. That is right.
So, and they say they even refer openly there to the criminal law.
Why would you want to put peace? I understand putting fucking CR in the time. Like I get it, but
it continues worship even in paragraph 21 when they do with Litecoin.
see, you know, when I look at this guy, so just off the top of my head here, like I go like that's probably the only time I get sort of liposuction is, you know, when you get that double chin going here, where you've got that extra skin. Like I don't know, I would take a fucking iron or something, but like that's the only time I'm going like, oh, I really want that. No, I was just pointing out. Listen, I'm just saying that's who it looks like.
Sabandi versus the Esther, the Timber led to the blood decision.
Oh God, is he just reading case law and going like, well, in this case, Yeah, exactly, Matthew. I completely agree with you.
So we say that
This is true. This is facts. These are facts. Matthew's just putting facts today. Right, that's why Matthew's a mod. I'm saying.
So it would seem that they seem to have emphasized cases that dealt with the Criminal Law Amendment Act, the Town case, and it carries on like that with distinguished, but there's no case
At least this is the fun
that they
thing.
can point out of celebratory shots being fired and the person receiving a prison sentence. And they also refer to the minimum sentence in paragraph 36.
Also, I'm waiting for a
The Dark Court decision. So what they say, Your Worship, is that the court must impose a
delivery
imprisonment, that they refer to cases that all, with respect, refer to minimum sentence in legislation and are not applicable here. And they say in paragraph 45, Your Worship, this is the strongest part of the case. In this case, the state submits that due to the fact that the accused testified, they plan to possess the two firearms, 9mm pistol.
Actually, it's like it's all over South Africa, and I've got a couple of people in the States, and yeah, I don't know, like it's quite all over. It's all over South Africa. I even had this weird guy called Renal Dog, who
Unity residing right around the stadium, of facts that places the accused in the sentence between 7 and 15 years imprisonment. They then ask for 10 years imprisonment, and then finally, Your Worship, they refer to the Zim decision which they've asked to be filed. And they say, lastly, the accused is treated and perceived with such contempt, took the citizens of South Africa for fools by trying to convince all that he fired a toy gun, blamed everyone except himself for his actions, confused the law with politics, practiced all intimidating tactics by hiding behind crowds, dragged everyone to be participants in his show. The show is over. This court must send out a strong message to other would-be offenders who fire shots among crowds and endangering the lives of others. If you commit a crime,
did they not have strong guys there?
And that's the conclusion there. Then, Your Worship, as I already said, they filed the supplementary heads of argument last Thursday, and there's a lot of, with respect, repetition, Your Worship. You'll see the introduction is very similar. They highlight the charges that he faces. They concede in paragraph 4, and this is where they go against their previous heads, that the minimum sentence legislation does not apply because they have not been warned accordingly. But they ask the court to impose a custodial sentence, and they do the aggravating features of the case, and they repeat everything that they said in the previous heads. There's nothing with respect to new, so I don't know what to supplementary about.
I don't put myself in a timeout. And then they lost the audio.
With our heads of
You just with the screen.
to respond to the heads of
Oh my God, these people are just terrible. Let's have a look quickly. Sorry about this. This is not me. This is I don't want to do ENCA. They're streaming thingy. ENC. They're live. Who else is there? Let's see.
Involve the public leader who planned to discharge live rounds from two firearms before 20,000 people as a rehearsed act of spectacle. And once again, Worship, I highlight, they tell you all along, treat him like a normal person, but they keep highlighting with respect that he's the leader of a political organization and you must punish him accordingly. So it's self-defeating with respect. They then also, in paragraph 10, they have a heading beneath it, 2 firearms, 22 live rounds before 20,000 people within a community. And they refer to the firearms being a 9mm handgun, Narinka SPA 249-14, 5.65 by 45mm, Remington semi-automatic assault rifle. But Your Worship, what they failed to record here, or even consider, they gave that back. So if they believe that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm, in paragraph 11, retains lethal kinetic energy on descent. The potential for mass casualties was real, foreseeable, and scientifically established, but we have the objective fact, Your Worship. And they say that it's pure fortune. that nobody was injured and there was no damage whatsoever, Your Worship, which is a factor that this court took into account in the judgment and ought to take into account on the sentence. It's one of the most important factors we're taking into account. And that's what they say in 12, Your Worship, that no one was killed or seriously injured. It was a matter of fortune, not mitigation. And then, Your Worship, in 15, they say that this conduct is a harm to the values of constitutional democracy itself.
Is this what he's going to do? He's just going to sit here the whole day and just read?
16, again, they say the court is therefore called upon not only to punish the accused for his individual conduct, but to vindicate the constitutional principle that public office and political prominence do not confer immunity from criminal sanction, which is the point that I'm making repetitively because they seem to go between those two approaches with respect to it. They then also refer to the decision of Hewitt as did we, and then they claim that the accused not only had an absence of remorse but also insight and accountability, and that he had maintained throughout and continues to maintain that he committed no offence despite being convicted after full trial on overwhelming evidence. This is the issue that Your Worship dealt with on record and recorded that it was his right.
What the hell is going on?
And then they say that he described these proceedings as an abuse of the NPA resources, an incompetent prosecution attributed the undisputed discharge of 22 live rounds.
Oh my God, you're joking. Okay, so let's get a backup stream going here because this is bullshit. Can't go through the world like this. This is terrible. Let's see. We got this one. Here we go. Yep. Let's switch over to this.
Automatic assault rifle. But Your Worship, what they failed to record here, what even considers, they gave that back.
Yeah, got a copyright
strike. If they believed that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm. This concession is remarkable. It speaks not to the uniqueness of a lenient outcome, but to the settled judicial view that such offences call for custodial sentences, a view Parliament endorsed through the enhanced penal jurisdiction measure. Now that cannot, with respect, be correct. We've handed, my learned friend wasn't aware of it, which I do concede, the more recent decision of the Eastern Cape, to Worship, where there was possession of an unlawful firearm. It was an illegal homemade firearm, and there was no custodial sentence imposed, and we dispute that such a concession was even made, Your Worship. We don't find it in the record. I know that sometimes the records aren't 100% accurate, but my learned friend can elaborate on that, because that appears from his supplementary that's filed last Thursday. Then they deal with the issue of Ms. Thompson's recommendations premised on a characterization of the possession as brief, benign, and celebratory. On the brevity, they say the brief duration of possession is relevant only where possession is accidental or fortuitous. They say here it was pre-planned and deliberate. Benignity, 22 live rounds. They said the ballistic risk was extreme. Celebratory purpose, they said the law does not distinguish between a reckless act done for enjoyment and one done for malice in assessing objective dangerousness. The rest we say is a repetition, but then they say, Your Worship, in 22, fourthly, Ms. Thompson's assessment of the risk of recidivism was superficial. She relied on the mere passage of the offence. She did not grapple with the fact that the accused who leads a political party that has staged multiple large-scale events since 2018 has demonstrated no acknowledgement that his conduct on 28 July 2008 was dangerous or unlawful. The absence of reoffending the income...
What's that? Hello, Whistler. Oh, finally. Oh, Whistler's finally decided.
Recidivism is defined.
Yeah, the SABC will flag you. I got a copyright strike from them last time, so you tell them Mulder this morning as well.
The clearest indication is looking back on time to say that such a thing reoccur.
Yeah,
so we submit that Ms. Thompson is accurate in that regard, and they, with respect, seem to have misinterpreted the term recidivism, and it wasn't superficial, because we look back in time, we say, were any other offences committed in that time? In the
Are
past
you
8
worse? Are
years,
you feeling
the
better?
answer is
It's
no,
Russia
because
interference.
it cleaned SAP.
Sorry, I just had to go pop in to go
so it
see
doesn't appear
if I
that-
had a
that
delivery
she's
I'm waiting
inaccurate
for.
in that regard.
The missus's birthday
They then
present to arrive.
respond
It's
to our
3 days
submissions,
late now.
Worship, on sentence, and they dispute that celebratory discharge cases are distinguishable. They say that you do have outcomes where there are no thing, but they say they're distinguishable. And then as dealt
Yeah,
with
his
in the
face looks very
previous
stressed. He also looks stressed when he did the conference the other day. He looked very, very stressed. I think, and based on that, that's what making my assessment. I think due to that, I think
Purdue was a
very
crime
good
of
job.
passion. Bader was a firearm and reckless endangerment, not discharge. So they say they're all different. And we say yes, Your Worship, but at the same time, and the most glaring fact, Your Worship, is they could not find one case in our whole history of all our cases, Your Worship, of shots being fired at a funeral or a celebration that resulted in a prosecution. And that's a fact that's
going to move it over to tomorrow.
And then they say the no harm, no injury argument misrepresents the nature and gravity of the charges. And they say no one was injured, no one damaged. The state acknowledges this, and that this they describe as being purely fortuitous. But what they don't mention here, Your Worship, and Your Worship went through the trial, so Your Worship knows, there was not one eyewitness that came to testify before this honourable court. The state was dominus litis. If anybody was in fear, out of all those 20,000 people that they now rely upon, it was incumbent upon them, either in the trial, Your Worship, or even in aggravation of sentence, to use their evidence, but they didn't.
What a terrible argument.
Even the SAPS who were on the stage, Your Worship, were not called by them to testify, even in aggravation of sentence, Your Worship. Not even the Gearhouse people, Your Worship, said that they feared or worried for their lives or ran away. No single person stood before this honourable court saying, I was afraid of being injured. I saw this as reckless, callous, and dangerous, which is something that they ought to have led if they wanted to prove that they were aggravating circumstances. They then, Your Worship, tried to fall back on their previous heads of arguments and say even where the minimum sentencing regime does not apply to case law, establishes a clear sentencing range for unlawful possession and discharge of semi-automatic firearms. They then quote our constitutional cases that we quote, so there's no, the principle is clear from that case, from the case of Makanyani, Your Worship,
we know why you
versus the Speaker. Then they changed the personal
Whistler was fraternizing with brisket dealers.
It's double-edged factor. It may be offered in mitigation of personal circumstances that is a public leader, member of parliament, but they say this is the most significant aggravating feature of the case. So now, Your Worship, they argue, treat him like any normal human being. At the same time, they say, no, this is the single most aggravating factor of the case. The two are mutually exclusive with respect.
No.
They acknowledge, Your Worship, in F, that all 5 counts arose from a single continuing incident. But they say the remaining counts serve to aggravate the primary count, not merely to establish its context. And then, in their concluding submissions, Your Worship, they go back with respect to the imperative of equality before the law. So you asked on the one hand to make an example of this accused because he's the leader, current leader of a political party. Then they tell you no. There's an imperative. You must make us all equal before the law. And they say there themselves, they say sentence that treats his case as an exception to well-established sentencing norms would itself be an act of unconstitutional discrimination against the poor in favour of those with means and the powerful. Now what we're saying, Worship, is they seem to imply that to impose a fine would be unconstitutional. It's not the case, Worship. You can impose a fine. It's recognised even in the post-constitutional era that a fine is a punishment, as is a suspended sentence, as are other forms of punishment. They're recognised. Then they ask for the imperative of proportionality and the imperative of deterrence. And then they repeat themselves, Your Worship, in paragraph 35 yet again, where they say, and I'm going to quote because you'll see just how many times they've said this, the accused has treated these proceedings with contempt. This is from the previous head, Your Worship. He fabricated a false account of a toy gun that was comprehensively dismantled by the overwhelming evidence at trial.
He lied
refused
about it.
to cooperate with investigators. He characterized this prosecution as an abuse of the NPA. He blamed VIP protectors, the Holy Spirit, and everyone except himself. The show is over. The court must now ensure that justice is done, not because the accused is prominent, but because the rule of law requires that every person who commits a serious offence faces a serious consequence. And they therefore go back to the zin as they did in the previous heads and ask Your Worship to impose. Now, Your Worship, what's lacking from all of this, and which leads into the allegation by the accused that this is an abuse of the NPA, is the objective fact, Your Worship, that we as a team and the state as a team, and I believe Your Worship too, were unable to find any case
Should have, but he's
of
a
any single
politician, and
individual who's ever been prosecuted for firing shots at a funeral or at an event or a celebration, despite all of us having seen that regularly.
I mean, they literally stated there were police on the scene. They did nothing. Because no one cares.
We
No one
therefore
really
say, Your
cares.
Worship, that a more appropriate
God, this guy's going to filibuster the whole day. He's going to do the whole day. They're probably going to swap lawyers as well.
And to impose a non-custodial sentence, which may incorporate a fine and a suspended sentence, and any other order, but to incarcerate the accused, we say would be startlingly disproportionate to the offences here.
Okay, do you rest your case? Are you done? There we go.
No, I have another right of reply. I'm my little friend's in a difficult position because his heads have been alluded to, but I'm sure he's going to add to them as well and deal with.
Yes, and then obviously you may reply
Yes, Your Worship,
if something.
I think
if
Mr.
there's-
Guy told you will do the reply.
She's talking, bro. Like, good lord.
Advocate Olive, there's just one aspect that I want to ask since you've raised it
Yes.
now, and I've read it in the heads and heard in the evidence of Ms. Thompson, and that is the part of the firearm being handed back before the court passed judgment. That is not within my knowledge. So,
It is, Your Worship. It's in her report. She testified before
no,
you.
it is in her report. I'm saying it's not within my knowledge. I'm hearing it from the defense.
No, Your Worship, yeah, there was no evidence. No, there was evidence there. She testified to that.
No, I don't
It's in
think
her
you...
report and it's in her testimony, and Your Worship, it's a logical conclusion. My learned friend
Logical
was in
conclusion.
court
That's
and would be aware of it, never disputed it once.
Yes. No,
So-
look, no, maybe I'm not... I heard her saying so. There's evidence by the defense regarding that.
funny, Judge.
I'm just not sure where it's coming from. You don't have to. I accept it's there. And as you say, it wasn't challenged, but it's not within the knowledge of the court that it was returned before judgment.
No, it is, Your Worship. It's in her report. She was there.
It's an
on it.
allegation.
No,
It's
I
an
was also
assertion.
standing by
It's
to
a
your
claim
point.
that it's
I've
been
given Your
returned.
Worship the page reference.
No,
and
I've
the
seen
report
it.
reference.
I know it's there. I do confirm it is contained in her report
And
and
had
in her
it-
evidence.
Had it not been the case, Your Worship, my learned friend was obliged to challenge on it, and he didn't. So it's an objective fact, and it's evidence that was laid before this honourable court. I don't know why there's a noise, Your Worship, and I don't align myself with it.
No, it's the
So let me
same.
repeat what I was saying, Your Worship. She testified, as Your Worship knows, it's in her report, and my
Yes.
learned friend was present and never
My
ever
learned
cross-examined her on
Yeah.
that aspect. So with respect, in
why
our
did they have to
submissions, a
make that-
proven piece of evidence before this honourable court.
Look, I hear you, I agree, and then I saw it in your heads, and that's why I thought I'll ask, because I'm not sure what the source of that information is,
Mr.
but it's
Savenga,
neither here
thank
nor
you,
there.
good sir.
As you
Shout out
say,
to
it's on
Tony
record.
Judge.
I'll
He's
hear
back.
if
There
the
we
state
go.
has any
There we
reply.
go.
But
Thank you,
it's
good
not-
sir, for the super chat.
Thank you.
Much
It's so noted.
appreciated.
Thank
Kind,
you.
kind, sir.
All right, Advocate Caesar, are you
Oh,
ready? Or
okay. Oh, don't tell me it's another one of their judges.
Let's get this over and done with the accused.
It's prosecution. Is this defense? Still defense. You can't see well because, like, put your microphone off, Danny Judge. Suki. Hot mic, baby. Hot
I
mic,
know
Danny
it's
Judge.
inconvenient. You don't have to move. We do have lady staff here who are requesting a bathroom break, which is 5 minutes. We can return within 5 minutes. Don't want to put anyone on the spot, but
That's Sean. How's it?
I'll just leave all my stuff right here,
Cool.
so I don't have to carry anything. Don't know who else, but sorry, the public, the gallery. If you do need to go out for facilities or water, etc., just please stick to the time frame so that we are back in time to proceed, because it's a lot who has to go out and back, and then 5 minutes becomes 15. So I know everyone can't manage in 5
Why
minutes,
is the
but
audio on
I'll
one
be
side?
right here.
It's just annoying me.
Sorry for that. Let us just allow everyone that.
Withdrawn.
So it's now, let me say, should we now just do the tea adjournment and get it over with? Is that
Good Lord.
fine?
Why do you need a
Do
tea
you want us
adjournment?
to do the
It's been
tea
an hour.
adjournment now?
Oh my
Then I
God.
return at exactly 11:15 and then we go right through.
Are you joking?
Fine.
Well, you arrived just
I
at the
can't
perfect
hear.
time.
The defense, is that in order? I can't
Yes, you
hear.
said, no, we don't have any.
Okay.
Yeah, of
Court
course
will
not. You're
adjourn
just going to
until
waste
11:15.
taxpayers' money. Go for it.
Oh, that if that's the case, then yes, the charge sheets. Then I'll take it.
Turn this down for a second. How you lot, Sean?
I'm good. How are you?
I'm great. I'm great. I'm awesome. It's interesting. It's interesting what's happening here. It's terrible. Honestly. Let's just turn it down. We're going on bro, like they start at like what, 9 o'clock, and then 20 past 9 they have a tea break.
Sounds right to me.
Yeah, it is. It's awesome. Well done. Yeah, no, let's hide this for, let's see, that's the other one. Yeah, everybody's going on a tea break. Let's we can chat for a bit. Yeah, no, it literally just CR, it just started. It's insane. It's like I mean, I'm going like, it would be cool to do this for a living, right? Just do nothing. Public gallery or peanut gallery. Aha. Where are all the armchair advocates at? Listen, today I identify as a learned advocate who knows the law. I think that's because they're all old. I mean, you saw the one dude, he's got that extra skinny at the bottom. So I mean, he can't talk for too long. Oh, we should actually do that. We should start a GoFundMe for Malema. Is that the ice cream truck or a police car or a?
And I'm hoping someone got stabbed. I'm hoping someone got stabbed. Yeah.
Does Darth work at Tab? It's TAB.
Why?
I don't know. It looks like you've got, looks like you're doing stuff there.
Where?
No, like behind you, there's a board up and all that. You know what I mean?
That?
Yeah.
Oh, that's my scoreboard.
Scoreboard. We can see what's happening. Oh, these are the protesters outside. Hang in. Yeah, I don't know. Do you think he looks? I don't know. He looks very happy. He looks happy. I don't know. This guy's nervous though. He'll be the worst judge. Do you think they'll protest his house if everything goes wrong? They're like, the EFF will go, you're a terrible judge. Yeah, I don't know, dude. I don't know. It looks like it's going to be an interesting day. CIC Julius Malema. criminal in control. Oh Lord, it's gonna be funny. So what have you been up to, Dr. Fuck, wait, day 1. Oh my God, how many days are they gonna do this for? They can't do this for more than more than one day. Oh, you're joking. This is going to be just annoying as hell, as all hell. Oh, fuck's sake. Anyway. So there's a poll on the SABC. What do you guys think the sentence handed down to Julius Malema? Suspended sentence? 67% of people believe that. Less than 12 months jail time, 9%. 3 to 5 years jail time. And I can't read the last one because they don't know how to share things on a screen properly here. Suspended sentence. Do you think? Yeah, I mean, this is the public thinking suspended sentence. What's your thoughts? What do you guys think? Suspended sentence? Final sentencing is tomorrow. You're joking. So, God, honestly, you know, I do feel sorry for though. Is not so much for myself, but I feel sorry for these people here. I feel sorry for the O's of here just sitting outside 2 days to support their dude. I don't know. Shame. Final sentencing. I'm just like, this is just annoying me. Why can't they just do it today? I mean, if the defense took an hour, and then the what do you call it? The prosecution takes an hour. What does she needs to assess? She kind of knows. She has to take it into account. Going, okay, if their argument isn't that much, she knows what she's going to be doing. That's the thing. She's been sitting for 3 days, or for the last when was the pre-trial sentencing, where he was found guilty? It was like a month ago. So she knows in the back of her head what she's going to do. I mean, this is it's kind of a bit ridiculous in my opinion, to have to wait for an entire day. Just come up and go, okay, I've taken into your account. Let's take a recess of an hour. I'm going to come back and then just go, here we go. This is my ruling. She knows before the time. Obviously, she had influence from a whole bunch of people, I'm assuming. Other judges. I'm trying to imagine, do you think she got any death sentences or death threats, not death sentences, death threats, anything like that came her way? I'm assuming she did. I mean, she has to keep that in the back of her head. I mean, imagine, that's also the part that we don't know, right? If someone sent her a death threat, and I'm sure they're going to do this, because it's going to be a serious blow to the EFF if Malema loses his position. If he gets a year sentence, he can't be in parliament. I mean, is that permanent? Is that a permanent fixture? Is it like forever? Let's ask Grok. I know he can't be in parliament again, but is it a permanent thing, as in forever ever? I think the Tani wants to make it airtight. We know Malema won't step a foot in jail if he is sentenced. Yeah. I mean, even if he does get sentenced, but I mean, that doesn't matter. If he gets a 2-year sentence, he'll probably go for medical parole, right? But that doesn't change anything. He still can't be a member of parliament. That doesn't mean he can't run the EFF anymore. He can still run the EFF. He can still be the head of the EFF. He's just not in parliament. And I mean, most of the time he isn't. But the thing that he wants that credibility of being on the board, where he gets to choose judges and shit like that. No, because Grayton is in parliament. See, there we go. See, if Grayton's in parliament, then what does it mean? Did he just lose his position? 5 years, no parliament. There we go. Thank you, Heidi. I mean, all he does is he just still runs the EFF. It's just going to give him more time to do more like basically branding, marketing, PR. And I mean, you know what'll be the worst thing in the world? Is if Julius Malema goes down the role of Gordon Hill Lewis, where he becomes this, TikTok, Instagram star, where he's just making content. That would kill me. Oh, it really I hope he goes to jail. Loophole or pull a Zuma. That's the thing. I'm thinking it's going to be something like that. I think it's going to be one of the two, where he's going to just go listen, well, you know what? Just gonna go medical parole. But the thing is, if he does get if he gets sentenced and he does do medical parole, he can't go on the thing. Maybe he'll get house arrest. He won't be able to go on go on protest missions and stuff like that while he's got medical parole. Do you know what I mean? So I don't think medical parole is going to be his vibe. I think he's hoping for a suspended sentence. But the advocate, his defense looks a bit worried. I was sweating bullets there, bro. He's like, I hope this turns out for the best. He's going to play the medical card. He hasn't lost weight for nothing. No, exactly.
But surely the opposition will go, okay, well, we want our doctors to take a look at him.
I mean, they didn't do that for Zuma.
No, I'm just saying, wouldn't that be logically?
I don't think that's
the word of my doctor.
Logically, that's how you assume it should work, right? That's the logical conclusion. If you go, if I'm supposed to go to jail and go, no, my doctor said I don't have to. Like, don't you get a state's doctor to then come look at you and go like, well, this is horseshit. Medical parole is not possible while Groenewald is minister. Wait, so does the medical parole have to be what do you call it? Greenlit by the minister of prisons? Is that how it works? That's also a good if Groenewald if Peter Groenewald has to make the call on that, then you know it's not going to happen. But I think that's what happened last time. The prisons board gave Zuma the all clear to go on medical parole. So yeah, I don't think that'll fly with Groenewald, with Peter Groenewald on the case. Which jail is he going to go to? Also, Polsmoor. Yeah, I hope if he goes to Polsmoor, I hope he takes loads of Vaseline with. They will be in jail, bro. They will. I'm going to get his salad tossed.
You can't handle the truth.
He will go to jail for 3 years with a further 5-year suspended sentence. I think.
I'm thinking he will get his salad tossed. I think he will have to toss salads.
No, he's not gonna have his salad tossed. He is going to be tossing salads. Because I mean, think about this, right? Say you're a career prisoner. Let's just pose a hypothetical, and like let's put it like this. Say you go to prison, right? And you're like a career prisoner. You're in there for life or some shit. And all of a sudden, someone famous comes in, like Jake Gyllenhaal or Brad Pitt or something like that, right? You're gonna go like you want bragging rights, like, you know what, Brad Pitt, you know what I mean? And I mean, I'm sure there's a bunch of prisoners in there like, but I don't like this dude, but he's still famous. That's what's gonna happen. They're gonna hold him down. They're gonna have his way and go like, brah, like, this is what I did. Like, this guy that was a worst to everybody, I made him my vafey. That's what's gonna. I'm assuming that's what happened. If I were a career prisoner, I would tune the O's. Like, hey, let's have him toss our salads and take photographs, and then try and blackmail him for money. That's the thing. But also the thing is, do we know which prison he'll be going to? Jesus, Heidi. Fuck me. That's rough. But that's, again, it's a bit of truth there. Oh yes, I almost forget. Oh, it is our good friend Jessica's birthday today, so please don't forget that, Sean.
Jess?
Yeah, it's Jess' birthday today.
Oh, fuck. Okay.
One day after Carmen. So cute. What am I doing now? Oh, wait, I have to quickly send an email. I can't believe they're going to have it's another 15, 12 minutes until they're back in. Bro, just next level vibes, government, right? The court system. What number will he get in prison? 28. You can pay for a single cell. If you have money, are you serious? What you would know. So Valerie, when you say you mentioned earlier, you get that you sort of involved somehow with prisons. What exactly do you do? Valerie, he will most likely go to the prison in Pretoria where he gets a single cell. But I mean, do we have like a non-violent? I know in America they've got like prisons on next level. Do we have the sort of prison system where certain prisons are sort of, low security type of thing, Oh, hold on, Sean. I just quickly I think I've got to get a package. Hold on.
Did he just bail on me? Now it's just me sitting on the stream on my own. All right, questions. What do you got? Any questions? I don't have an opinion about this. I don't really know what's happening. Stop distracting me. What's up, guys? What's happening? What's up with Bonsai. It's a fake bonsai. It's not even real. That's how sad it is. It's just a plastic bonsai. It's not a real thing. Darth, what's the score? Okay, the scoreboard is about, so every time someone pisses me off, they get a mark. As you can see. Oh no, it's flipped, so you're not going to be able to see. But yeah, every time someone pisses me off, they get a mark, and yeah, it's it's like my kill list. So when it gets filled, either way, I'm going to, unsubscribe them. That's my goal. Yeah. Take Diddy's advice and invest in J&J. Tell us about the score. Okay, but yeah, because the scoreboard is when someone pisses me off. Yeah.
Sorry. Just got a package. Finally.
I also have a package.
Take Diddy's advice and invest in Johnson & Johnson. That's a good idea. That's a very good idea for him. I would send, but I mean, I just want to know what prison he'll be in, so that we can like maybe post him. It would be a cool gift, right? We can all chip in and we buy him like one of those, like, big Vaseline tubs, and we can send it to him. I think it would be nice. I think it'd be nice, like a nice gesture. Let's hope. Let's hope. Let's see what happens here. Yes, money can buy you anything in prison: cell phones, single cells, protection, good food, weapons for stabbing. Yeah, I mean, the thing is, it's all the only issue is with him is I think he's more worried about the fact that he won't be able to go out and do marketing. That's the main vibe with Malema, and the fact that he'll lose his position, which is his power, for 5 years. The head of the judicial committee. I mean, I saw a video of him. Yeah, I think it was yesterday. He was like in the thing where they were picking judges. Do you know what I mean? Like, you don't want a person like this picking judges. Yeah, we do this. I wish we had made this before the time. I would love to brand him, send him a branded butt plug. It would basically work like protection, right? If you think about it. No, we can't send him a taser hose kit, Matthew. Can't send him a taser hose kit because, like, we don't want to help him get out of prison. Yeah, most likely. Hold on, I just got to send a work mail quickly. What are we standing on here? What time is left? Like 7-8 minutes. Yeah, tea time.
I mean,
we're paying for that.
Really?
Well, can't they just bring? I mean, can't they just grab like a? I mean, why do they have to have a tea time? You started at 9 o'clock. Have tea at like.
Well, I mean, like, I think what you need to do is you need to understand he's most likely not going to be able to get tea in prison, so he's got to use every opportunity that he can now to have as much tea as prison. He's going to have like something else, like They're
going to stretch this out forever. That's what they're going to do. This is the thing that I'm always.
Yeah.
They're going to stretch it out forever. I mean, the fact that they're going to do another day, it's really annoying me. What's for dinner today, guys? Dinner. I haven't even thought that far away. Oh, I must say, I had amazing sushi last night. I went to Obi last night for the missus' birthday. It was phenomenal. It was lovely. It was I just love Obi. Sushi is just the business. I can't hear you. I saw you talking. And then you just stop talking. I was thinking he would do that. I mean, I would probably not a bad idea to do that just before, before you go in, is to just exercise. Audio trolling. I know that's what he's doing. He's being a dick. We've got our poll so far. We've got a 53% no that he's not going to get any jail time. Your lack of faith in Tani Judge is a bit annoying, guys. Come on. We want him to go to jail. What list? What list are you on there? Oh, here's the vibe from the here's the thing. SABC. What do you think of the sentence handed down to Julius Malema? Suspended sentence, less than 12 months jail term, 3 to 5 years, and I can't read the last one because they've put their stupid banner over it. So yeah, the majority of people believe out of 5,800, say 6,000 people, they think suspended sentence. Yeah, yeah, we must send all Tani Judge all the good vibes today. No, I think it's going to be shocking though. I think it's going to be a shocker if he does get jail time, because I think the default of our country is that we think that there's never been a case where politicians actually face the music, right? So the default is corruption. These people always get off. So yeah, that's the I think that's why you have this kind of vibe here where people go like, yeah, he's going to get a suspended sentence, because that's always what happens to politicians. No one faces any music, no one faces accountability for the things that you've done. It's just, and that's why you have this thing where they go suspended sentence. What a shit place to, like, a country to live in where that's the default, right? The default is, yeah, politicians get away with whatever the fuck they want to. I mean, how long did this court case take now? 8 years? That's the thing. That's what I'm hoping for. But you know what's going to happen, Chantal, when like, if she does hand out a jail sentence, she's going to be literally, and that's the thing that you have to consider, that's probably going through her head, that the judge is thinking. She's going to be maligned as a racist judge, because if they've already called her that, they're going to go, no, she's a racist. They're going to find out where she lives, all that shit. It's, that's going to happen. Why are you laughing, Darth Sean?
I was just realizing a lot of people are asking about my list.
How do you get on that list?
Yeah.
What do you have to do?
So what I've decided, I'm going to make a list at home for everyone on the stream. And it's every time someone pisses me off, you get a mark, you get a stripe.
Oh, okay.
Do something good, you also get a stripe. So it's like a scoreboard. Yeah. But someone did ask, hold on, just checking. I think it was RJ. Can one get off the list? No. Once you're on the list, you're on the list. It depends on, it depends on how bad your violation was.
What are the violations? What are, like, I've
even put myself on the list as well, on my list behind me. Yeah, it's just like whenever I piss myself off, I give myself a mark.
What do you do to piss yourself off?
I don't know. Just, I feel like, like, because obviously, like, there's the logical side of me and then there's the illogical side of me. So the two of them are constantly at it.
Poor darling.
Yeah, but once you're on the list, you're on the list.
You're on the list for life.
Yeah, you're on the list for life,
and you can't get off.
That would have gotten you a good mark. I agree with you 100%. Thank you. So for the list, I'm actually taking a one and create a list, and you're gonna get a good mark. Yeah. So, and then it's the whole list is when I become a dictator, you won't get executed. It depends on. I'm going to unsubscribe you.
Matthew, you can't just give me Bidens for just trying to get on Sean's good side. With great power comes great responsibility. I will revoke powers. You mustn't misuse them, Matthew. Come now, good sir.
Matthew. You do what you want, Matthew.
I need to get that. I need to get that audio. But
Matthew, that's why I gave Mork that's why I gave Mork a Biden moment. I want to get on.
Pull your tongue out of my arsehole, Gary.
yeah.
Pull your tongue out of my arsehole, Gary.
There we go. That's for RJ. Guys are fucking tossing Darth Sean salad here. I don't need lists. I've got a memory like an effluent.
I've got a list. It's the opposite of Schindler's List.
The opposite of Schindler's List. You mean like the Führer's list?
Not to save anyone.
Oh God. Oh, thanks, CR. No, it's good. No, it's cool, CR. Why don't you back to Ronaldo's stream, huh? Traitor Ginger. Never trusted Ginger. Never trusted Ginger. Bastard. Oh, here we go. We back, baby. We back. Danny Judge.
I'm gonna mute myself because I've got gardeners cutting.
No, it's cool.
But I am, I'm gonna be here, yeah. So you can talk, I can hear you.
You're otherwise, then I can do full screen.
Sorry, before we proceed, we just want to check if the fire is interfering with the recording at all. We hope not. And then we'll be ready. Please be seated, Mr. Malema. You may proceed, Mr. Caesar. Everyone from the defense also ready to proceed? Thank you.
Can you, Worship, just inform everybody again that the cell phones must be switched off or on silent?
The gallery, you heard that? Is our interpreter here? Ms. Mavla, please. Thank you.
Now it's the defense's turn.
Caesar, I'm ready if you are.
Thank you, Worship. Worship, I don't know how council expect me to impress my bosses if he has done half of my job for me. One thing is certain, I'm not going to pay him 1 cent for that, Your Worship, for doing or attempting to do my work for me.
Please go ahead.
Your Worship, when I was at the magistrate's course many years ago, they had this 3D dimension on the board where we each were required to say or what exactly was on that particular 3D dimension. Some saw elephants, I saw a head of a man, an old man, even some saw a lion, some saw 3 heads. The point that I'm trying to make, Your Worship, is that we're looking at the exact same set of facts with different views relating to that particular fact. That is the court's duty to find which one is the more plausible argument. It's not for me to minimize counsel's argument and vice versa. There's just 2 aspects that I need to rectify right from the beginning. The issue relating to the filing of heads. My heads, I confirm it was filed on the 1st of April. The issue that I need to address is the condemnation issue, because I did call Mr. Mkwanazi on the 31st, informing him that my heads are ready, it's ready to be filed. I wasn't in office, I was on the road, and I did not want to send unsigned heads,
This guy's
which
taking
he
his-
confirmed
take
that
his
there
time
will be no
forever.
issue.
If it's
Why
stuff like
counsel
this,
raised it
it's
like I had to
all
apply for condemnation? To me, that is sufficient. It was filed first thing on the 1st
Oh my God. Oh my
of
God.
April,
This is where we're
when I
starting.
got back to the
Shoot
office.
me. Oh.
The second issue that I also relating to the condemnation, I did not read counsel's heads on the 31st. Reason being, as I already explained, I was on the road, I was not in office, I was unable to read it. That's the reason why I contacted the attorney, Mr. Mkwanazi, because I did not have any other person's number.
Oh my God, the dramatic pauses. My guy, come on. Let's go, let's go,
It's
let's
my
go.
view, a response to the heads of counsel in the supplementary heads. There's no need to apply for condemnation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. It was given back to accused number 2 on the day when he was found not guilty.
Did someone leave their vibrator on? What's like? Do you guys hear that?
There
Bro,
was
the
a prior
pause.
agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there's no need for the firearm to be kept further. If I might read, just to assist
Wow,
counsel,
this is why we need
what
2
this
days, guys.
particular section says relating to that.
We've got those dramatic pauses.
Sure.
This is gonna be. I get why we need 2 days now. Now it may all make sense. It's all cleared up now.
I think it's been the bright light behind you may cause a glare, I'm not sure.
If you can ask my little colleague, because it's so, I will actually ask counsel to read that particular part for me. You must read section 30 and then section 31(1), because I can't see. I don't know if it's the
Just
right one.
borrow someone's spectacles at Caesar.
It's time. It's time.
It's time that you go and get spectacles.
Sure.
Oh, he's got
Look.
them there, look.
Yes, you should.
Sorry.
I
Oh,
got the spectacles.
now we,
Yo, it's
we
much
are in a
better.
spectacle. All
Much,
right.
much better. Section 30 deals with disposal by a police official of an article after
Oh my
seizure.
God.
A police official who seizes any article referred to in section 20, which we know it's articles which they lawfully entitled to seize from an accused or a suspect
Who
or any
cares?
person who is
And shut it.
suspected to have committed a crime. To whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interests of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen with the consent of the person from whom it was seized, deliver the articles to the person
It happened
from
8 years
whom,
ago.
in the opinion
Lord.
of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to read the last
Please
one.
don't. Please don't.
C.
Just get to it.
I'm going to go to section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in section 30C, or if it appears that such article
Charmaine,
is not
exactly.
required at the trial
No,
for
Charmaine.
purposes of evidence
I don't know.
or for
This
purposes
is-
of any
what we've
order
dealt
of
with it.
court,
I don't know why we're doing
the
this.
articles shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it.
Those glasses look dirty, hey?
We
It
had
looks
no
like
need
it's
for
smudgy.
that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and that he be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup, because we were perfectly within our right to return it. The investigating officer has retired. If that article went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the
What does any
same
of this
storm in a
matter?
teacup that was made about the laptop, where the video evidence was stolen, despite the fact that it was
I'm growing my hair out.
kept on another
Like
hard
the-
drive.
like you look at
The
screen.
laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there; it was already collected, just as the article prescribes.
Yeah, I know
Since
the
that
budget's
issue
big
now
as
has
well,
been
RJ.
dealt with, and the law allows
wanna-
us to do so,
I just don't want to do the SABC stream because they'll
I want to
copyright
deal with
strike
the
you.
issue relating to Section 9 of the Constitution, because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offenses, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law.
The DNC catchphrase, no one is above the law.
I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the
Yes,
street.
because he's not just a public figure. He's a minister. He's a parliamentary member. He's a leader of a political
So
party.
far as sentencing was concerned, the court is well aware that
Thank you.
courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest
Microsoft.
of society. I'm not going to go through my ads
One, two.
page
Testing.
by page, but we have referred to State versus Banda and others.
Okay, sorry, advocacy. So I follow you. Are you doing a combination of
Is that a bit better?
first and second, or which
Oh, I
one
just-
are you
I just
busy
like
with
wearing it
now?
I'm busy with page 2.
of the first report.
Grey hair,
Yes,
and
it's the
my
first
hair's
one.
busy growing out because I shaved it too high on the sides here. I went too high and I've got to grow out.
Use of the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson.
That looks.
I will deal with the flaws of her evidence when I refer to my supplementary heads of
I
argument.
think I did misread. I'm dyslexic, Andreas.
It seems that basically she relies
You
on
can
those
compare it
factors
to
that the
HDR.
accused did not injure somebody,
Yeah,
that he possessed a
right, right,
firearm
right.
for a short period of time. And then she made a recommendation because he also have
I
a
fell
soup
asleep there.
kitchen that he is responsible for,
What?
that he should get a non-custodial sentence.
Because he's got a soup kitchen. Fuck off.
I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks this
Look at his
morning.
soup
I am
kitchen, I
going to
can't
go
get
through
it
it
down.
now. I will deal with it briefly, just briefly. If the court allows me time to read it properly,
No, we don't have time. God.
I can
come
produce many
on.
similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I didn't deem it necessary to hand this particular judgment up
Winky stop.
by the
That's it, Lynn.
DJP, the Deputy Judge, now retired Judge President Van Zyl,
Okay, what did he
where
say?
he has an opposite view regarding firearms, the matter of
course.
it's an appeal matter,
Ooh,
a full bench appeal judgment,
sounds like a big
the matter of
deal.
Romeo Jansen,
Who's Romeo?
case number
Tell us.
CANR
C-A-and-R.
220/18.
Just read. No one's taking notes of this. Just read it.
Just want to see the date when the judgment was delivered on the 29th of August 2019.
Okay.
This is a full bench matter where
All right,
he held
get
the
to it.
exact opposite view of what Justice Brooks held regarding the possession of firearm, and this already outweigh the judgment as counsel has handed up of Mr. Nolan Linzima Ndila, because this is a full bench judgment of the same division.
Okay, you said this
I'm going
now.
to
Just,
give counsel
just
a copy
read
as
it.
well, if I may
Oh,
hand it
for
up
Lord.
for the court's
All right,
benefit.
cool. Awesome. Thank you, Guy. There we go. Now can we read it? This chick is in the back here. Is like, listen, this is such bullshit. She stopped recording. It's like I couldn't be bothered anymore. I love the buzz, eh? Just lovely buzz in the left-hand side of my ear. My right-hand side, sorry. Can you? I can't. I wish I could do ×2 speed.
Your Worship doesn't even have to be concerned. The fact that the judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms.
Are you gonna read? Just read it already. Good Lord, bro.
We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court.
She's a
the
judge.
reason
She
why
knows.
these judgments are relied on by the
Oh my God, he's
Supreme
gonna get
Court of
off,
Appeal
isn't he?
because
He's
of
gonna
the
get off.
different
He's gonna get
judgments
off.
from
Fuck,
different
alright.
divisions, talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing.
Put the glasses on. Please put the glasses on. Someone clean it for him in the meantime. Just
He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one in that Romeo Johnson appeal matter.
But you waiting for like little nods from the judge to carry on? What is he waiting for? What are you waiting for, huh?
Your Worship, I want to be upfront that the state
You are up front. You're standing and
custodial
talking.
sentence, and if we can get the maximum sentence of 15 years, Council correctly said that we do not rely on the Minimum Sentence Act.
No. Maximum sentence. Are you waiting for it to go yes? What is it that pauses, brother?
We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose
That's also true.
at least a 15-year term imprisonment.
There we go. Exactly,
It was
Valerie.
without
Justice
being
for VBS
prescriptive.
victims.
It is correct that the custodial sentence will send out a clear message. Council referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw it on television once, is the one that was highlighted by the deputy mayor, I think, of the Nice Now George municipality.
That's true, Kevin. That's very true. Yes, exactly. But it's almost like he's
Outcry
waiting for a
because
response,
of that.
Valerie. He's like, he stares and goes,
Shows
"She's
that
gonna-
that should
she's gonna-"
not be tolerated in a civilized society, where people's lives are placed in danger for people who are in a celebratory mood, firing shots. And in most cases, these people are unqualified to fire such shots.
Next point. I mean, again, I think people should be allowed to shoot what the fuck they want to. But listen, if we
In
put
this
rules,
instance, accused did not just fire one shot and left it at that, which we can consider to be an accident.
yeah, it was no accident. It was all on purpose. He was happy. What are you waiting for?
He was
Oh
malice,
my.
to say the least.
I can't follow. I honestly struggling to follow. What are you waiting for?
His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdansane, which we know is one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdansane.
True.
It was by the grace of God that
100%,
nobody
RJ.
got
They
hurt.
did mislead the court. They said it was a fake gun. It wasn't real.
I think I repeated that I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet. I'll order you to leave. There won't be a choice.
Yeah. Come on, Tani Judge. Tune them.
Please interpret, Ms. Margot.
No, he does, Valerie. I just wish he would articulate it a bit quicker and stop doing the super pauses. It feels like he's reading bullet points really slowly.
Ms. Margot.
Exactly, RJ.
Advocate Caesar, you may proceed.
Thank you.
Thank you so
Thank you,
much,
Judge.
Your Worship. The accused is a political leader.
Yes.
He's got a huge following.
Yes. Pause. It's just a little too long. Go.
Young people emulate this type of behavior.
What are you doing? What are you doing?
What he doesn't realize is that he already opened the Pandora's box,
Oh my God.
where he creates the impression that this type of conduct...
They lost the left audio. That buzz wasn't there for nothing. Or did I lose my audio? Let me see. Oh yeah, they lost right side audio. Hopefully they've got fucking sound people. Let me just plug in my normal ones and recharge these for a bit. This is the audio is terrible. Let's see if we can find another stream here. This is bullshit.
Anybody else, you would have screamed that that person should go to prison. But now the foot or the shoes on the other foot is screaming, give me a custodial sentence. This counsel already mentioned what I was about to say in most of these cases.
Let's try this one.
But what I want to read to the court is the case on paragraph 4. On page 4, paragraph 10 of my heads of argument, which is one of State versus Lister. The citation is in my heads of argument. This issue particularly deals with Thompson's evidence, and our court
It's worse.
particularly deals with Thompson's evidence and how the court should view such particular evidence. I want to quote, I remain unpersuaded by the submission in counsel's heads of argument that the court should have adopted an opinion of Dr. Sidley that a goal sentence would undermine the treatment to which she would have to submit herself. Prison, one knows, is not a congenial place, and the conditions may well be less than ideal for psychotherapy. But then a prison is primarily an institution of punishment, not a cure. As the court of quo was at pains to point, the approach of a sentencing officer is not the same as that of a psychiatrist, and if I might add, also a probation officer or a social worker. The sentencing officer takes into account all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with the diagnosis and rehabilitation.
What the fuck
The
is that?
psychiatrist is concerned to focus on the well-being of an accused at the expense of the other aims of sentencing, such as the interest of the community
Wow.
as a disturbed
Stream's a
process,
bit low though, sorry.
and to produce, in all likelihood, a warped sentence. Now, I went through the Oxford Dictionary to try to understand what this word warp means.
WAP. Ask Nicki Minaj.
It's something twisted,
It is.
bent, or mishappen.
What? Something completely different there, buddy.
It's something diverted from its original form. It also refers to a distorted. Can I borrow the glasses again?
Yo, that's just low res though. What the hell? Come on, people.
It's regarded as abnormal. I'm definitely going for an eye test after this show.
No, just clean the glasses, bro. That's all you need to do.
It's been now for a while.
Just clean the glasses.
It
That's all you
refers
need
to
to
a
do.
distorted abnormal or perverse mental state or sense of humor or twisted moral values. If the accused get a non-custodial sentence, but this is basically what the law now would go to, it will tell people that it's okay that if you fire shots, whether it's 1 or 2 or 10 or 15 or 22, it's fine, you'll just get a fine, non-custodial sentence, because this is what the type of sentences the courts are imposed. Whereas it's my submission, it's not. All the cases that I've listed in my heads of argument, all the accused got direct imprisonment. Counsel also stated that I referred to the Minimum Sentence Act. I concede the accused was not warned. The fact of the matter is, the point that we were trying to make, that the Minimum Sentence Act and the Malgas judgment is at pains to explain that courts should impose standardized sentences, whether it's minimum over 15, 15 and up, or maximum 15 and down. The sentences should be more or less the same, depending on the facts of that particular case.
The pauses just kill me. Honestly, they kill me.
I did not refer to Malgas because I want to draw the court's attention that the accused should get the minimum sentence, which is 15 years and above. I drew the court's attention to the Malgas case to inform the court that that's basically what it boils down to, that for certain type of offenses, standardized sentences, whether it's minimum or maximum, should be imposed. That was the intention of the legislator. In State versus Delport, I'm at page 5 of my head. Paragraph 14. I quote, "There will undoubtedly still be a gradation of seriousness attached to the unlawful possession of firearm. In this respect, much will turn on the circumstances in which the unlawful possession occurred. There will be cases in which it will be evident that the possession, although
Do you think he's
unlawful,
tweeting? Should we go check out
was
Twitter?
relatively innocuous,
We're going to check out Twitter, see if he's tweeting.
and that the weapon was unlikely to have been kept or used for any nefarious purpose. It refers to a sentence of 15 years imprisonment in such cases would clearly be disproportionate and irreconcilable with a constitutionality compatible implementation of the prescribed minimum sentence regime. There will often be an evidential burden on an accused person to give an explanation showing that his possession of an unlicensed firearm was relatively benign. That will be all the more so when the weapon concerned is prohibited.
Oh, he's not
weapon.
tweeting.
We know
Hasn't said anything.
these were 2 firearms that were fired.
Why are they masked, though? They're going to take him to jail.
Submission that nobody came to come and testify. We argued this point already. We had all the evidence. The video evidence was the silent witness. It gave us everything that we needed to know. No witness would have been able to describe everything that we saw on that video. To rely on the fact that no witness came to complain and so on is neither here or there, or that we did not call any witnesses in aggravation of sentence is either neither or there. The video speaks for itself. They say a picture speaks 1,000 words. This is one of
That's
them.
oh, God, I love this dude, though.
I always have an issue when I see words like innocuous and so on. I'd like to consult the dictionary to understand what is this person trying to say.
I completely agree, Marvin.
He uses words like that.
Life boy. Soap on a rope, baby.
The word in this innocuous, in this context, is not harmful. Injuries. It describes something safe, inoffensive, or unlikely to cause disapproval. It often refers to remarks, behaviors, or substances that seem harmless, but may not be. Synonyms include harmless, safe, innocent, inoffensive. We know for a fact that this firearm was not fired. Both of them were not fired innocently. This accused testified he planned it. And when asked, why did you choose a particular direction to fire, he says, don't tell me how to fire a shot. I can fire it even from underneath the stage if I feel to do so. It is not innocent.
Julian, it's the sentencing of Julius Malema for shooting a gun, firearm.
His intention was clear. He was going to do whatever he wanted to do, regardless of the circumstances and the situation and the danger it might have caused to the people around him.
It's basically like final arguments, and then judge is going to pass sentencing either today or tomorrow.
People were running. He disputed it until the last minute, but the evidence was there. We've seen it. There were 7 people in the direction, 20,000 right around where he was standing. For him to rely on the police that did not charge him and all that, that's an issue that needs to be dealt with by the police themselves in their internal investigations.
Oh, you guys are fucking hilarious, honestly. The comments are the best. Just
I've already highlighted to this court why I referred to the Malchus case. And just to be clear, that it is against this background that sentencing for firearm-related offences.
We're going to show now.
We're
at the mercy of the camera. I'm not controlling that.
The question arises as to whether a standardized and consistent result, as was envisaged by in the Malchus case, has indeed been achieved in respect of sentencing for the possession of semi-automatic firearms. We know that this one was an assault rifle, despite it being semi-automatic. Its size of the ammunition is dangerous. It's bigger, it's more powerful,
bigger bullets,
and could have had fatal consequences.
Yeah, if he had to shoot somebody. But I mean, he shot a gun in public. God, like, we know this. Just get to the sentencing. Where's Tony Judge? Tony Judge, come on.
So the Supreme Court of Appeal referred to the tendency of the courts to use, even if only it's a starting point, historical sentencing patterns as a provisional standard for comparison when deciding whether a prescribed sentence should be regarded as unjust. Again, like I said earlier, it's neither whether it's a minimum sentence that's applicable or maximum sentence, but a standardized approach to sentences for certain offenses.
Oh, yes, sorry, that's Julius's, the defense is talking. Julius's lawyer has already spoken, my bag.
I've referred to all the judgments that counsel have assisted me, Marikane, Asma, Ronklai, Suganda,
That's insane.
Timo, Lahi, Vadboy, Lordlo, Tau, Mkobo. The judgments
he identifies as black. That's the thing.
In my view, to more or less the same similar circumstances, not the firing. I don't want to be misunderstood when counsel reply.
Oh God, is counsel still going to reply?
It's not the firing of the shots for celebratory purposes and so on. I don't want to be misunderstood. But what I understand, what I want to point out, these people did not have the firearm for long periods of time. I have referred to it in my cross-examination of Ms. Thompson. It's the matter of State versus SWAT, where the appellant was convicted on 2 counts of unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts in view of the fact that the appellant had offered a denial of possession, which denial was found to be false, which is the same as this instance. He said he had a firearm, he said it's a toy. He still maintains it's a toy, regardless of the evidence, already overwhelming evidence proving otherwise, that this was indeed a real firearm owned by the owner, which we gave the firearm back to, which was ballistically linked. Back to after he was found not guilty and discharged. And furthermore, that no mitigating circumstance in relation to his possession could be inferred. The court held in the Swartz case that there was nothing to place his unlawful possession of the firearm in a less heinous light than that which motivated the lawmaker to lay down a minimum sentence of 15 years. However, on a further count of unlawful possession of a semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. This gentleman had 2 firearms. Ms. Thompson testified, said, yeah, well,
As he closing
2
arguments.
firearms, not taking into consideration, even when it was pointed out to her that the accused fired with 2 different caliber firearms, which he denied that he knew that the one was smaller or bigger, something that was so obvious to see. I don't know firearms well, but you know one is a rifle, the big one, and one is small,
Thank
it's
you.
a handgun.
Thank you, Sydney.
In this regard, the court held that the state accepted the appellant's version to the effect that he fortuitously came across the firearm in a rubbish dump and was apprehended the same day. Here, Ms. Thompson was saying, yeah, we didn't know how long did he have it, and all the fact of the matter is, a day has got 24 hours in it, and he was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made in the spur of the moment. Furthermore, it was held that the appellant did not have the firearm in his possession for a very long before he was apprehended. He didn't have it long, same as was alluded by Ms. Thompson, yet this is the sentence the appellant was given. One was 15 years in respect of the one firearm, then on the other firearm, the sentence was reduced to one, my memory serves me correctly, of 7 years imprisonment.
Give him 7 years, baby. 7 years, come on. Come on. 7 years.
The court held that the circumstances of the crime were such as to make a sentence of 15-year imprisonment thus proportionate. That was the one that he did not have for a long time. The other one, we didn't know how long he had the firearm in his possession.
Hours, CR. Lots of hours he spent
What I want
in
to
court.
point out in this particular matter, it's not said whether he fired shots with this particular firearm or not, or whether he used it in the commission of further offenses. My memory served me correctly. Counsel, Mr. Ndukaitobi did point out that matter. Is just I can't remember what exactly was said regarding that
Does he have a
particular point.
cold
The fact
sore
of the
on
matter
his
is
lip?
that he did not have the firearm for a long time.
Do you think he got that on purpose, just in case?
So in State versus
I was gonna get
Delport,
kissed in jail.
dealing with a fully automatic firearm, Benswar J expressed reservations about the suggestion in some judgments that the possession of a unlicensed firearm should be treated as serious only if the weapon had been used for the commission of the offense. The point that I just raised just before this, it looks like the impression is created that if you have a firearm in your possession, you should commit other serious offenses for you to qualify for a 15-year imprisonment, which is not the intention of the legislator. That's why the Firearms Control Act was enacted, because of the seriousness, and the Parliament deemed it necessary, the legislator deemed it necessary to make a specific act for firearms because of the serious nature that it poses. The legislator did that in order to single it out for harsh punishment. You are already guided by the cases in the Supreme Court of Appeal. You don't need to really consider all the other cases, whereas there's already authority from the Supreme Court of Appeal saying that harsh punishment should be imposed. In both Thembaletu and Rontlai, the Supreme Court of Appeal upheld the minimum sentence for the possession of semi-automatic firearms. So in cases where an accused is convicted of a standalone offense of unlawful possession of a semi-automatic, the courts are taking an increasingly unsympathetic stance towards offenders, and terms of imprisonment to the range of 7 to 10 years imprisonment are commonly imposed.
Yes, you've said this now. Let's get to the response now. Yeah, there's pauses, right?
In addition, the accused's personal circumstances, one of the most important factors in deciding an appropriate sentence, is his explanation as to how the unlawful possession came about. What did he say? He's planned it all along. Him and the EFF planned.
What? What happened there? Let's switch. Sorry, don't know what's going on. This stream bugged out. Oh, it bugged out. Hold on. I'll switch back as soon as they get. Sorry about that, ladies and gents. We'll resume that other stream as soon as it gets back up and running again. On the fly, baby. On the fly, trying to make this work. Russian interference.
It seems that the judicial safety increasingly does not support the view that possession of an
That was great. How was your weekend?
should be treated as serious only if the weapon has been used in the commission of the offense. And in this case, we know for a fact that if he used it. He was found guilty of all the other alternative counts or the other counts because he has used them. He was charged for that.
So the audio is terrible.
And he was convicted of those offenses.
Sorry about this, ladies and gentlemen.
I've already alluded to the fact that there were so many people there. And the danger.
Terrible audio. Terrible.
Posed to that community, the supporters.
We can actually switch over between. Let's maybe try the SABC one.
Therefore, the state prays for the maximum sentence of 14 years imprisonment in light of these aggravating circumstances and factors that are already pointed out to the court. Without being prescriptive, the court.
All right.
And in respect of the
Can't hear shit.
possession, unlawful possession of firearm, the accused should actually be charged being in possession of at least 22 of those live ammunition. Because
Let's pop this one up just for.
one of those were linked to that firearm, it should 1370.
Okay.
Logic dictates that the others
Multiple
system
options,
went out
yeah.
before that was also live ammunition. In respect of count 3, 4, and 5, the state will submit that fines may be imposed.
Terrible sound. Good lord.
Impose such type of things, and that we said it's because of what it's in a single event, different counts arising from one single intent, that these sentences may.
Let's get this one as a backup.
I know counsel said this already when he read my ex paragraph 47 on page 30, as I was concluding, that the accused have treated this proceeding with such contempt. He took the citizens of South Africa for fools, when he tried to convince everybody that he fired a toy gun. Everybody can see that it's not a toy gun.
No one thought it was a toy gun. No one. Literally no one.
He blamed everybody for
Oh,
his
we got
action.
some lag here.
He confused the law with politics. He practiced all intimidating tactics by hiding behind crowds. Dragged us to be participants in this show. It's time for this court to tell you that this show is over. Court must send out a strong message to other offenders who fire shots amongst crowds and endangering the lives of others. That if you do commit the crime,
CPU is
you
taking
will
it.
do the time.
There we go. Yes, those pauses. Exactly, dude. But they can't because they want to own all of it. Wait, let's try the SABC stream for a little bit.
Other than the one that they gave us
Oh,
this
that's
morning,
loud.
that Makoliana versus the EFF the speaker for a broad constitutional proposition about value of liberty in the role of the court. I submit that these authorities are entirely inapplicable to the present sentencing inquiry. It's not applicable, it deals with the death penalty. We are not seeking the death penalty.
I really just don't want to use the
Its
SABC
ratio
stream.
has
That's
no
terrible.
application to the imposition of a proportional custodial sentence for serious firearms offences. It doesn't even relate to firearms.
I know, Matthew.
It concerns a constitutional crisis involving Parliament. Observations about the rule of the courts as a stabilizing force support the state's
Right,
position.
well, switch back.
Courts as a stabilizing force support the state's position. Courts
Sorry,
must uphold
I know the audio's a bit cuck here, but I
Mr. Swartz was sent to prison. Another gentleman I referred to also was sent to prison. How fair will that be? Will that be a consistent, standardized approach? If a non-custodial sentence, what must Mr. Swartz think when he hears or sees that he accused because of his standing in society, the fact that he's famous, that he did not get a custodial sentence like the ordinary man on the street? It's my submission that will be really a discrimination.
ENCA is using the same stream that I am. Let me just double check.
So where it affirmed the constitutional value of individual liberty, the state does not
Yeah.
seek to ignore
ENC
that value.
eyewitness use ENCA is the one that's gone down, unfortunately.
Must be balanced against the rights of 20,000 persons.
Oh, it's back up. There we go. Thank you.
And against the rights of society to equal and consistent application of the criminal law. said in my head that it was a double-edged sword, and the court must understand it to remain.
There we go.
Above 7 years and up, it's because of his position and the precedent that he created by doing such.
There we go. Back and running, guys. Back and running. Thanks, Matthew. Yeah, back up.
Usually the case of Pretorius was never charged for being in possession of a firearm.
Yeah. He was charged for shooting it.
He was charged for discharging
There we go,
a
exactly.
firearm in a restaurant of 200
Oh,
people. He was charged with unlawful possession of ammunition and not possession of firearm. For the defense to rely on that issue for the firearm related offense, it's displaced. Because that issue, he was imposed that type of sentence for that discharge in a restaurant. If you multiply, I don't know how my accounts, that was 100 times more. In this case, Pretorius fired shots accidentally, and he was imposed a suspended sentence.
that's very true.
In contrast with the accused who fired, according to him, deliberately so. He says he can fire any way he feels deems fit. Yeah, this man was apologetic because he knew he was not supposed to do that. In this case, the accused says, I can do as I please. Don't tell me how to conduct my business.
Good point. Good point. I hope this will be I hope this is
So the
going to set a
200
standard, different
people
standard.
were multiply this by 100, then we'll get to 20,000 people. That's how serious this was. Oscar Pretorius 200, he accused fired 20,000 people plus excluding the community around the Ndansane area.
Good point.
So the aggravating factors, just to conclude, that the court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that she can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do a job, just to compile a report for the purposes of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report because she was paid for it. His absence of remorse, insight, and accountability. Until today, he still doesn't see what he did, what danger it posed, and what its consequences could have been. His position as a public leader and a role model. Role
model.
And to society.
Role
The fact that
model.
he's a lawmaker breaking the law. Firearms were used
Sorry about that.
and live ammunitions were fired. Not once, like in Oscar Pretorius, not twice, but multiple times. The
Of course,
degree
Matthew.
premeditation
For you,
involved
anytime. zoom in
and
on
deliberate conduct
Malema.
puts him in the category for 7 to 15 years.
I wonder what soap I'm going to get.
If the court imposes a custodial sentence,
I agree,
it will
Valerie.
satisfy the principles as set out in State versus Zinn. And the court will do its constitutional mandate of equal treatment before the law,
Yes.
and will serve the legitimate and pressing interest of a society that has the right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, unless there's anything else the court wants to hear on.
Thank you.
That's also a very, very, very good point from Freedom. Yeah, very, very good point. That is a consideration, right? And also, like, a consideration the judge has to take into account. Holy guys, come on, easy with the microphones. Is the consideration of like how his followers will respond. I mean, you've seen all the people outside there. How are they going to respond when there's a guilty sentence? Oh, here we go. Defense time. Oh, jeez. Guys, easy. Just turn that down just a smidgen. God, it's like breaking my eardrums. This is like, how many lawyers does he have? 1, 2, 3, 4, 5, 6. 6 lawyers. They're just gonna take the whole rest of the day and just go, well, I thought this is sentencing. What are we doing here?
Thank you.
All right, my learned friend has one more issue.
Oh God, okay.
Just one issue that I also need to put on record, that Mr. Snyman, the state conceded that it did not prove its case beyond reasonable doubt, that it was unable to show in the video or see in the video that it was Mr. Snyman that gave the firearm to Mr. Malema. That part was inconclusive, and that's what's the reason why Mr. Snyman was acquitted. Thank you.
Let's do that. Cover the logo.
Your Worship, thank you. I have 5 points to reply to.
5 points.
The first one
Shoot through them, buddy.
is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson, and paragraph 50.4, where she says, it appears that the accused received the rifle, ready to shoot, from someone authorized to possess and handle it, most likely from the Tactical Security Services. The provided security services.
Adman, thank you.
However, no individual was convicted of supplying or transferring the firearm to the accused, and this is the crucial part. And the rifle was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. That's the first part of the source. Then, if your leadership then goes to the transcript of the evidence of Ms. Thompson at page 35, at line 8, she says, however, no individual was convicted
That's a very,
of
very good
supply
point,
or
Matthew.
transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment.
Doesn't matter, he shot it.
This trial. Now, why does this matter?
Yeah, why does it matter?
It matters because the
The law.
Forfeiture of firearms that are used in the commission of offences.
He's trying to get him off on a technicality. That's what it sounds like.
My learned friend has already referred us to section 30 of the Criminal Procedure Act. But your ladyship will discover that section 30 is actually inapplicable in the current circumstances because it deals with disposal by police officials of articles after seizure.
So what?
It doesn't deal with articles that are part and parcel of the criminal proceedings themselves.
So what? Irrelevant.
Similarly, section 31, which is another section that was relied upon by my learned friend,
Lied upon.
refers to disposal of articles where no criminal proceedings are instituted or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles after Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that will be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this Act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your ladyship to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It is not up to the state.
Everybody's asking the exact same question, Admin. I don't know. It's like it's supposed to be closing arguments. I don't know what they're trying to argue now. They're trying to influence her decision.
That deals with the forfeiture. So your ladyship will know under section 34 you may order the item to be
Kangaroo
returned,
court.
but under section 35 you may order the item forfeited to the state as well.
What does this
Because
have
under
pertain to the
section 35
case?
subsection 1, it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed, or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this Act, forfeited to the state. So what happened here is that the prosecutors, on their own showing, agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect.
What does that matter, though?
Whereas the provision, section 34, says the judge or the magistrate, whoever is presiding, may make that order. But it raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment about the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as my learned friend points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they have this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument. which your ladyship can just dismiss without more. So we submit, therefore, your ladyship, that there is a potential irregularity
Okay.
which flows from the non-compliance with Section 34 of the Criminal Procedure Act.
What
and
does
the
that have to pertain to the
non-compliance
case,
potentially
though?
with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there, we take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the issue?
Oh my good
of
lord!
commission
Is
of
that
the
is that the
offense
argument here?
prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the impropriety of the conduct of the state.
Very good point, Ulrich.
The second question I want to address then is to
It's
look
the inversion
closely at why does the state say
of
Mr. Malema
justice.
should go to jail?
Yeah, why
This
shouldn't
is
he?
clearer,
Make an
because
argument.
the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary
Good
heads
one, bad
because
one.
there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated.
It's premeditated. They sing
That
the
it seems
song.
that they actually misread the evidence.
Oh, you're
Because
joking.
The planning that Mr. Malema talks about, if
Bullshit.
you look at the supplementary heads of argument, your ladyship will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense. He's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they have imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of offenses usually show an element of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship will see from our heads of argument. The second conviction is about 1 bullet. It's 1 bullet, not the 22 bullets, 1 bullet. So ordinary cases of premeditation do not have that element, because what we find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about 1 bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were. but what the court said the findings were. And the important ones is 1.2. Unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act, to wit. Now, those
technicalities.
words,
It's
to wit,
technicalities.
usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. A .223 Remington bullet, one bullet, without holding its license, permit, dealer's license, manufacturer's license, gunsmith license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady.
He still shot multiple rounds.
The findings are distorted. It's a narrative building.
No, it's really, yeah. They're trying to get him off on technicalities.
Well,
That's what they're trying to argue here.
Points me to even the first finding is unlawful possession of a firearm, not the firearms. A firearm, one bullet.
Not one bullet, multiple bullets.
So we've got a problem here that
Still
when
shot
you
them.
Look at the second reason why they say Mr. Malema should go to prison. There is a disjuncture between what the state says and what the court found. Wow. And then you can't do this. You can't send somebody to prison for reasons that the judge did not find.
You shot the gun, brah.
So this is the problem now with item 2. 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct.
It was multiple shots.
And then ask yourself, in those circumstances, should I send this man to prison?
Exactly,
and
CR.
He's so upset that they say, don't only send him to prison, send him to prison for 15 years. It's like a game that they're playing.
Oh, you're playing a game.
To inflame the passions of the public.
What? Our passions aren't
Then
inflamed,
the next
bruh.
reason why they say Mr. Malema should go to jail is, if you look at their supplementary heads, because he's a public leader in their own way. Now here, and I sympathize with the state, that we say, well, people that are holding positions of society
He's
should
influencing
take responsibility.
an illegal act of shooting guns in public.
Good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we
Very
were
true.
here during the evidence of Ms. Thompson, when your ladyship commented, and they say, what's so special about him? The state says he's special. When
He
we
says
now
he's
say
special.
today,
It's in his
treating
title,
the
CIC.
prison of Section 9, everyone is equal before the law.
Yes, he is
So in
equal
other
for
words,
law.
my lady, what we have is that we've got the state that chops and changes its case depending on what it wants to achieve.
Adding
at a particular
motivation.
point in time.
God.
Today, they're trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentary. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that.
Yep.
But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC?
Because he broke the law.
And the fact that
He's already been
the
found
fourth
guilty,
part
dude.
of it is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment.
because he
And no
wants to
one
keep
can
his seat.
sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument.
So he should get a
posted by
lesser
the
sentence because he's a
There's only
politician.
one punishment as far as they're concerned, is custodial.
Come on.
So what we say, my lady, is that you have a range of penal options that would reflect the society's disapproval of
That's also
say,
true,
public
Harman.
misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite.
Again,
So we
exactly,
say that
Valerie.
ultimately is a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say... in
He has no
two
remorse.
instances, absence of remorse is not an aggravating factor. State says that in paragraph 17 of the Act.
Oh, okay.
It's not an aggravating factor.
All right, cool. So
But my
this,
lady, there is a fundamental legal problem with the argument.
what?
If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal, because the magistrate has wrongly
No.
found him guilty.
Hold on.
The state says, infer from that he is not remorseful. It's absurd, because even under Section 35 of the Constitution, he has a right to an appeal.
No,
And the
his
right to an
appealing
appeal
is not
based
unremorseful.
on a view held
God.
by an accused wrongly or what? That the magistrate is wrong. You cannot say,
He
I'm
claimed
going
it's
to
racism.
punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong.
That's also true.
And
Very
I'm going
true,
to appeal.
Chantal.
The judges on appeal may say to him, Mr. Malema, it is you who's wrong, and not the judge. But in expressing a penalty, a judge cannot say, I'm going to punish you more because you've said this absence of remorse just because you say, I do not agree.
His public statements,
And I want to
regardless
take
of
this
this,
point
that is
further
the
about
issue.
the absence of remorse. They say Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent.
The soup kitchen.
That's what they say in their heads of finding. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you
Google
know
it.
what happens? They violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished because
No.
it's not retributive, which is
He's
fine for
disputing
sentencing, but
the
it's vindictive,
judgment of the court, of the
which is
judicial
in conflict with
system.
the Constitution. So we say your ladyship
Okay.
cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph
He's a
18.
public
where
official
in B they said,
to uphold the
"It describes the
Constitution,"
proceedings
and
on
he's not.
abuse of the LPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution
here we
of
go.
Mr. Malema.
No, sorry. No. Advocate that is not a reason for mitigation here. We are dealing with mitigation and I am indulging the defense.
My lady, it's 18B.
You've
of
stepped
the
over the line, buddy.
18B of
On
this
which
case.
one? Supplementary or the
Supplementary,
first? 18?
B. So there they say, Mr. Malema complains of a political vendetta by AfriForum. That's the point I'm addressing. Leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nkukaitobi. I'm just quickly reading what you are referring me to before,
Calm down,
before
buddy.
saying
Calm
that
down.
I don't want you to say it. Let me just read the paragraph.
Thank you, Madam.
Take a sip of water, relax.
Okay. Advocate Nku, Nkul I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
My lady, it is the state that says that Mr. Malema lacks remorse because he has blamed Afrifora. I'm simply explaining.
And the Holy Spirit, including
Yes, I'm not dealing with the Holy Spirit, I'm dealing with Afrifora.
Please leave.
The Holy Spirit, what?
So I was very clear that there will be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused. It's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all.
Yeah,
so do you leave or what? Because I'm not going
just
to
tell them to
tolerate.
leave. Judge, study judge.
So there's a whoever wants to comment, please leave.
Yeah, bye. Oh, I'm commenting, so I can't leave because I'm not there.
Whoever is commenting now, please leave. And from now on, I will leave that in the hands of SAPS. Whoever comments or speaks, ask them to
remove them.
leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just make one sentence on
No
Afrifora,
jokes.
because I think that's what is increasing the temperature inside.
I'm listening.
Yes. My lady, Mr. Malema is entitled to regard Afrifora as a political adversary and to criticize it for an unfair prosecution because he believes that they are behind his prosecution. What you cannot do, you cannot take that political statement by Mr. Malema and take it to account in sentencing.
I hear you fully, yes.
Thank you, my lady. Then they are also complaining that he has complained of racism.
He has.
Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism?
Because he's
Makes no
accusing
sense
the
to me at all.
judiciary of finding him guilty because of
Not going to
racism.
respond, but I'm listening, yes.
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against him? Why would they have an issue?
Because he was found guilty.
And why
claimed
would the
because of
leadership be
racism.
required to put that in your judgment in sentencing? Now, the last one is the Holy Spirit. Nothing needs to be said about that. Then C
That's-
is showing no insight to the danger of 20,000 people. But if you look at closely, my lady, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D, he has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the courts from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told come on the 9th to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your ladyship that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so where the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making earlier, paragraph 19. Critically, the probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the constitutional court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone else thinks I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. If you did that, you then violate Section 35 of the Constitution that gives him the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your ladyship has been given this case, Janssen versus the state, by Fanseil DJP. My lady, this case is
that needs to be factored in, 100% RJ. He lied to the court about the gun.
With previous convictions, it is a case where minimum sentencing legislation applies.
I hope the prosecution brings that up, though.
Where it says the appellant
with all the
firearm.
clauses.
Robbenheimer ran away and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. This is a case of gangsters. It's not a case of a politician in a temporary lapse.
Exactly,
shoots
dude.
a firearm.
You call Tony Judge a racist.
This is a case of proper gangsters. There is absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases. And again, this is another misconception. We've cited, and I will ask your ladyship when you retire to have regard to these judgments. In paragraph 31 of our heads of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Cluster J, S versus Mitigation, where he refers to, I think at that point, all sentences that he was aware of on possession. So, my lady, you see, S versus Malema, the sentence that it was an automatic firearm, not semi-automatic, automatic. The sentence was, there was a direct imprisonment. On appeal, it was altered to 2,000 hours of periodic imprisonment. S versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment.
2,000 rand or 18 months imprisonment. How does those two things correlate?
Our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases.
We'll have to see the outcome.
And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fayun, S versus Pistorius, Munsami, and another, and the Bada versus S, paragraph 41. Yes, 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there is no harm,
The soup kitchen.
no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found, you discharge the firearm in the sky. I mean, Pretoria's case was actually a paradigmic one, because it's actually in an enclosed room. It's like here in the court.
Oh, so it's better if it's outside.
Full of people, and then Oscar shoots the fire. It's not his firearm. Someone else shoots it to the roof.
Okay.
And then they say 3 years fully suspended. Don't go to prison for it. So the pattern on discharges when no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says, that there are cases you will find of 7 years. But virtually every case we've looked at that they have cited always involves, like this one we've looked at, gangsters or some sort of other offense that is, the possession is part and parcel thereof. Not one case involves an instance, which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it aside the crowd, bring it back to me. Never found a case like that. So it is not correct for my learned friends to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you have, you really have a wide canvas. A wide canvas that starts from only suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. My learned friend can complain about Ms. Thompson's bias, etc., but the fact of the matter is there is only one witness on sentencing, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discretion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you, my lady.
Thank you, Advocate Nkoka.
Right.
Thank you.
Any judge?
There's no provision for you to reply, Advocate Caesar. This is it.
It's done now.
The defense, am I going to indulge him? It's not procedure. He's trying, he wants to rise, so
Let's
you
swap
may
quickly.
outvote to rise, so you may outvote him.
It's supplementary to Darrell's full argument, and even after his arguments, he had an extra point.
Okay, the extra point I disregard, but with the rest, we stick to procedure. Is it a new point?
Just get to the sentencing. They're going to call it now. And then we have to come back tomorrow. She's not going to be able to make a decision. Come, Tani Judge.
What you want is not raise the point, but on what is the basis of you wanting to do so, that I can listen to and then I can tell you yes or no.
No, you was just going to advise counsel to read section 30 and 34.
No, okay. That is a no. All right. Thank you, Advocate Caesar. All right. So that is us for the day.
Oh, you're joking.
But then, since no one is speaking to your leadership when you ask me, that is it. The one thing we agree with the state on is that we need to get finished with this.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate it.
Advocate Nkukai Toby, let me be
Come
very
on.
clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is still to be decided. Let me explain so that everyone, and I'm sure I do not have to explain.
It
You
costs
are
money,
all
Tani Judge.
senior officials and very much aware of what I'm about to say. What you read on paper materializes when it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and
I have absolutely no problem. Your Lordship is adjourning us to a date to be advised.
No, we've got 2 days, and I intend to
Oh my God.
do our utmost to reach our end goal.
Just end
I
goal it
just
now.
don't want to say and commit after I've explained why, and you all know when you read and when someone says it's a different, totally different impact
Come, Tani
when
Judge.
you hear and when you read in your office. It's then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. So we can, sorry, I see I'm keeping you on your feet, but you are free to take a seat.
Costs money, Judge. Tani Judge.
I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that, or we can say 9 a.m., but I'm not going to go beyond that. So
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can
Do it today, babe.
notice Caesar, your client.
Take a break and then
I'm thinking of all the media stations and subs to return for me to read out a formality which is known to all, or
Yes.
come back at 9 a.m. But I intend, as I say, not to go beyond and for us to reach our goal as
come, Tani
planned.
Judge. Verdict, verdict.
Then your word is my command.
What is he doing?
Agree, Advocate Caesar? All defense? All right.
Okay, so what are we doing, Tani Judge? Are we going to read it now? So you're going to read all the formalities. Tani Judge reads very slowly. This is the only downside here. Let's switch streams, see what's going on. Has he got a cold sore? Got a cold sore in there. What is she doing? Trying to get his attention. Julius, look here. Julius, look. Look, photo. I'm not sure what's happening. What the hell happened there? Hold on. That's weird. EFF just dropped this. No, the ENCA just dropped their stream. So let's see what's going to happen here. Don't you just love this comment here? 2026, year of victory or death. So, do we know what's going on? Can you judge? Okay, I'm going to be back in a second, guys. I'll just quickly want to do something.
Mr. Malema, just a minute, please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it is the same venue, but I'm also directed by the management. I assume it's the same, 8:30 for us to start at 9 a.m. I'm sure at the same venue, which is High Court venue. Okay. Thank you. Court will adjourn.
Wait, so we're adjourning now? What? Is that it? Are they adjourning for how long? Did they say? You're kidding me. No sentence. What? Oh, sorry. You agree. I read that wrong. My apologies. So we're not coming back tomorrow. Is that the vibe now? Dance first, tax puppets, dance. That's weird. Let me see. What's going on? We have to come back tomorrow and do this bullshit over again. Hold on. Oh, tomorrow 9 a.m. Fine. Let's do it tomorrow then. We're gonna do another stream tomorrow morning. What time? What time should we do this? Damn it. Yeah, I don't know, guys. Yeah, so it's gonna be tomorrow morning. Fine. I'll make a stream for tomorrow morning. Should I do it now? Schedule a new one. Schedule a broadcast. All right, let's someone do that right now, and then we can redirect to that stream. What time are you guys good with tomorrow morning? Let's see what the chat says. Hold on. Let's get the chat open. 9 a.m. 8:30. Why we do like quarter to 9? Because I think it's all it's. How do I get a Biden there? 9 a.m. Quarter to 9. So I start before. We can give like, chip in and say stuff. Thanks, Val. Yeah, see you tomorrow morning. Thank you for hanging again. Everybody that was here, thank you so much for hanging out. Hit the like and the subscribe. 5 a.m. Kevin. No, let's do it like just before 9. Let's do quarter to 9. Or like 5 to 10 to 9 or something. Because I want to see what's going on. It's gonna be super awesome. I want to see what's gonna happen. I want it to go down. So yeah, start at 6 a.m. Lots of rock music. No. Me 6 a.m. Are you just? No. Let's do like just before 9 o'clock. Let's say like quarter two sounds good. 9 o'clock. Sounds like a good time. Roll's boring, so I'm here now. Yay! Thank you. Oh, Ronaldo's not always boring. He's a good lad. He's a good lad. Okay, cool. So let's do that then. Let's schedule it right now. While we're I think I need to do it from. My other laptop. Cool. Let's just do it from here. Schedule a stream for tomorrow. And then what I'll do is I'll redirect to that, and then you guys can go join that stream, which would be quite cool if you don't mind. That would be super fun. So let's just get all our ducks in a row here quickly. And then once you redirect, just give it a thumbs up or something, and then set a reminder for tomorrow morning. That would be really awesome of you guys. Let me just quickly do this. Okay, there we go. Redirect, cool. I just quickly want to set this up. Right, let's quickly set up the stream for tomorrow morning. And I think let's stream on X as well. Let's just do it at the same time. Let's just do a multi-stream. That's going to be super fun. get a multi-stream going. I've got myself here as well. Schedule a broadcast. Right. Let's do Twitch, and let's also do X. This always takes a minute. And I mean, while we're here, bye guys, I need to get meds for the pharmacy. Chantal, I hope you feel better, babes. Honestly, I really hope you feel better for tomorrow. Yeah. You guys must have a wonderful day. But I'm not leaving yet. Give me like 5 minutes. If you guys have any questions, we can chat some questions. Ask away if you want to. Let the kids walk. I did. What? Let the kids walk? What do you mean? Where's Darth Sean? Ah, Darth Sean. Why do I even bother? Oh God, a lot of copy and pasting. Sorry. Too far? What's too far? What's too far? Chantal? Elabbing rate. Julius Malema, sentencing. I just need to put a cover on. Oh, this takes such a schlep. Let's see, what time tomorrow morning? Thursday, we're gonna do it at let's do 8:45. So we get 15 minutes of talking a bit of cuck, and then we can. What games do I play? I'm currently playing Jedi Fallen Order. I just finished that. It's the second time I'm playing it, or second time I'm playing it, and I'm currently playing Jedi Survivor on PlayStation, on my PS5. That's how I roll. That's how I roll. And PC, I don't really play a lot of PC games. That's the one thing I don't do. I really want to try and get more into that, but I just don't. I just don't play enough PC games. I the mouse and keyboard. I used to be a PC gamer, then I switched over to this, and I just can't get back into it. Let's just quickly get, which one should we do? Let's do this one. Get a bit of a new updated cover for tomorrow. Yeah, here we go. And just want to quickly get all this stuff. Julius Malema. Shame. What do you guys actually think? Do you think he's gonna get the prison time? He's gonna get Vaseline. My house from school is 3 kilometers. Oh, okay. This is Andreas. He said, "Let the kids walk. It's too far." Yeah, 3 kilometers is a bit far. Fallen Order was great. I did not like Survivor. I know you can use the controller for PC, but like, you know what the difference is? Is like me sitting up right here. I need like a sort of, I like lying down playing games, like full relaxation mode. That's the vibe. So I think that's why sometimes I'm like, I don't know. Playing here, it feels like work environment. You know what I mean? Okay, let's just get that. Got that. All our ducks are in a row. Cool. Set that. Got all our things. Julius Malema sentencing, South Africa EFF. Let's pop that one there. X. Cool. Julius Malema sentencing tomorrow live. Sorted. Okay, let's create this schedule. Got the time right, got the date right. What's tomorrow? Today's the 6th. Am I just double checking here? Yes. Okay, schedule it, and then we're going to redirect to that one. Also, upper room, Peter Savenga, when are you doing your stream, bro? Like, you really got me upset last night because I'm thinking there's a Tuesday night's like a thing now, and now it's not. Upper room Mork rock shit. I don't mind popping in for a bit of banter in the morning. That'd be cool. Survival Africa. Thanks, Valerie. BF6. What the fuck does that mean? What's your best game? My best game? That's really a difficult one, dude. I don't know. I mean, I'm more of a single player. I don't do multiplayer. I did put. I liked ESO Online. It's one of the great games I've played. But I mean, God of War. I kind of like God of War, the new ones. I don't have a best game. It's difficult to do that, to go best game ever. It's like, what's your best movie ever? What's your best song? I don't. There's no way in the world I could actually pinpoint that. And say that. Okay, cool. So the stream is up. Let us set a redirect. There we go. Right. So once this is finished, it's going to redirect to that, and then then please just go give it a thumbs up, set a reminder, and then tomorrow morning. I didn't have time to prep yesterday's show. Are you going to do one tonight, or you're only going to do one Sunday and then next Tuesday, Peter? If that's the thing. I mean, we all know there's corruption, right? But the thing is, like, and this is what I was trying to point out early on, is going like, we don't know what's going through the judge's head, right? She was already maligned as a racist, so that's not going to be an issue. But we don't know the extent of threats towards people. I mean, there was like 2 weeks ago, the lawyer that just got shot in the middle of the road, in the middle of the street. Oh, look, it's back. Oh, it's very loud there, Daltron. Oh, okay. That's not going to work. Background audio for days. Okay, that's better.
Just got back. I had a shootout.
Oh, cool.
Yeah.
Yeah, I'm just gonna. So it looks like we have to come back tomorrow morning.
What did it finish off with?
Nothing. It basically, they just. I don't know. Well, it's if you have to relate it to sort of an American vibe, right? It was kind of closing arguments, but I mean, it's like in America, what happens is like you go, okay, cool, you found guilty, and now the sentence is da 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 da. Or like, there's a delay between that. I don't know why there's closing arguments after that. It's like because they're trying to make an argument for what the punishment should be, and that should be up to the judge. So again, like they're welcome to make arguments, but I mean, I don't know what the point of that is. It's like, here's an argument going like, well,
the decision of the judge, I'm assuming.
It should be, sorry. Did I not say that? Yeah. Sorry, I meant to say that it should be up to the purview of the judge. The judge should go, okay, listen, these are the reasons. I've taken both matters into account, and I think this whole vibe was here going, okay, cool. Well, we think this and this.
Sentencing then tomorrow. Like we'll find out.
So tomorrow, But now, obviously, she's going to it's going to probably be like an hour or 2 hours, because she's going to do the same thing she did there. She needs to make sure she follows the letter of the law. She's going to read out exactly, this is with this reason. So, it could be like a half an hour speech that she's going to read, because she's going to she has to make an argument. And
well, because obviously you got to drag it out. Like, I'm assuming you're going to drag it out, and
I think that's what's going to happen. Well, I don't think she needs to drag it out. I mean, they could have adjourned and come back like 2 hours later.
Get it done.
Because the thing is, this costs money. Like, think about like all the money, like the amount of like having your lawyers there, having the court open, the media companies, the people outside. I mean, this is the only thing, is the people outside tomorrow, the EFF supporters, like where are they going to sleep tonight? And luckily, maybe she's thinking, maybe it's a good idea to extend it, because then they're going to be really tired tomorrow. So if they get bad news, they can't really protest and burn shit down. How's it, Arbot? I saw your thing. You didn't get a notification. This is weird. Also, like, I was Googling. I was doing Malema live while we were live. The first half an hour, my stream didn't even come up as in the search. I'm very annoyed by that. I'm very, very annoyed. Wait, is Julius from Zimbabwe?
But in mine it came up though. Like when I opened up YouTube, because I knew today was the sentencing, and I knew you were doing a stream, so I opened up and it was in my feed.
Oh my god, that's the best name ever. The guy just subscribed. My guy. Awesome. Awesome name. Let's see. Yeah, that's weird. It should be getting notifications. Oh, here we go. Wait, hold on. Oh, let's see. Is this live? The feed went down. They were showing people outside. Yeah, okay, their feed is terrible. But let's see. There's just nothing. I want to see what they're doing. It's just gone black. I think he's going to give a speech now. I'll stay and do the speech because it's like the whole vibe is like they're going. He's like his arguments like he's not being remorseful. I mean, when the precedent when he got found guilty, he came out and called the what do you call it, the judge. What the fuck is that?
It's some. If I say
Julian,
something,
don't say anything.
That's yeah.
Don't
So,
say-
but we
don't
all
say
know
anything.
what I'm talking about.
Plumbers? Did you see the guy who ran down the street naked? What? No. Where? Pop it in Discord. What guy ran down the street naked? What sounds so gay? You're gay.
Plumbers. I'm assuming when you said plumbers.
Plumbers. Yeah. See, I'm trying to check their stream is just dead here. They were like showing the people outside, but it's just not working. Let's see. Are they still trying to 330 people watching? I don't know. I don't know what's happening. They were supposed to do a Julius Malema attends pre-sentencing hearing. Yeah, I don't know. I don't know if this is. Let's see what Ronaldo's. Oh no, he's got his vibe for tomorrow. Oh, he's also doing his thing tomorrow. There we go. Let's give him a like. Go like our good friend Ronaldo's vibe. Right, let's see. Yeah, no, I don't see their stream's just gone down. It's just gone black. Yeah, I think maybe I should keep it there. I was making fun of the subscriber whose name is fine, I'll take a Biden for that. I didn't get that one. Sorry, Kev. Sorry, Matthew. Yeah, no, like doesn't look like there's anything up. But he's probably going to give a speech now. I couldn't give two shits about it. I care about what's happening. How's the list coming along, Darth? Have you adding obviously the people to the list?
Yeah,
outside?
so I'm gonna start adding people, but I'm figuring because like there's so many people, so I'm gonna start off with like three people that annoy me the most. So it's gonna be Mork, Whistler, and Ronaldo. You're gonna be on top of the list, and then obviously as we go, and someone like, you piss me off, you've made the list, and then the score.
Oh, okay.
Yeah.
Okay, I see.
Yeah, so I've got like two sections. One is it's okay-ish, and then unsubscribe.
Oh, really?
Yeah.
Okay, we've got everything sorted. Kif, right. Listen, I think then I'm going to call it there because there's nothing happening at the EFF, and I've got stuff to go do. Got to go. There's a whole bunch of fucking emails I need to get to, otherwise. Yeah. Oh wait. Oh, just as I'm about to leave.
Come back.
What? No, their stream went live. Do you want? I just want to peer in just for a few seconds. Let's just see. Oh no, that stream looks horrible. I don't think I'll be able to do this. This is holy. Oh God, no. It's
loud.
Jesus, it broke my eardrum. I think no, their stream's fucked and their audio is broken.
Who's chatting?
Let me show you. I'll show you. Listen, just turn your volumes down. I've turned this down as much as I can. Listen to this. This is terrible. The volume is on its lowest. Look there. Jesus, bro. Data. Yeah, you're going to jail. Do the song. Do the song. Come on.
You what it is? It's the guy that's doing the sound. He's gonna. Everything is just full.
Yeah, bro. It's just like full of it. It's like,
yeah,
let's push it up.
Yeah.
See, their stream is buggered, bro.
Yeah, just like their leader.
Do the song. Do the song. It's the last time you can do the song. Come and do the song. Down, Afri for them. Down with the stem. I don't. Sanitary General.
Do the song, and then someone should just hand him another gun.
Yeah.
And just go, no, we checked. It's all cool. Just do it.
Don't worry. Yeah. Communist quality control. The KFC song. Oh Lord. I can't, bro. Just how's that microphone? Did they put another microphone to record the audio just in front of the mic or something?
Yeah, just in front of the speaker.
The fucking speakers are breaking, bro. They're gonna have to spend an extra couple of $100,000 on paying the sound guys for this terrible job.
Hello there.
It's trying to silence. Niels, thank you, Niels. Thank you for subscribing. Much appreciated, good sir. We're almost at 3,000. Almost at 3,000 subscribers. We're going to catch up with Ronaldo in days now. Well, kind of. You are going to be silenced when you go to jail, buddy. If you go to jail, you'll be silenced. Sing for your chicken. Yes, it's rough. This sounds like a YouTube dub. Dude, I know, dude. It's audio is terrible. Look here. Look where I've got the audio. On almost 0. And it's like when I had it, it was on full. I think I maybe broke a speaker, my earphone or something. Judgment. Actually, I know. I don't care. I can't even hear what he's saying. I wonder if they're using empty. What they're using empty, and if there's like a hard line. Obviously, they don't have a hard line there. Journalist. Okay, I don't actually give a shit. Fuck this. Yeah, you can piss right off. I don't care. It's just audio is so god awful. I can't. I just can't. Guys, yeah, I think I'll call it there. I need to go do some work. It's almost 1 o'clock. And then I'll catch you guys tomorrow morning. My ears were bleeding. I think they're bleeding. Probably gonna start bleeding very soon. Internal bleeding, yeah. Yeah, so guys, we're going to see you guys tomorrow morning at 9:15. I'll be here. We'll spend 5-10 minutes talking a bit of cuck, and then we'll jump on the stream, and then we'll see what happens. We'll see what the Dunny judge comes out with. Let's hope. Let's all hold thumbs. What you should do is if you have Vaseline at home, just grab the Vaseline and just put your hand on the Vaseline, and then just, send a wish into the ether. They need more than Starlink. They need BE Starlink. It just doesn't ever work. Cool. So yeah, guys, please, if you can, I'm going to redirect to the video. Please hit the notification to remind you tomorrow, and then hopefully we'll get some better viewership tomorrow. Guys, have a wonderful day. Darth Sean, thanks for popping in, saying hi. We'll catch you guys in the morning. Sweet. Have a fun, super fun, awesome day of awesomeness. We'll catch you guys later. All right. Bye.